Good afternoon. Call to order. The meeting will now come to order. Welcome to the October 11th, 2021 meeting of the City of Raleigh Board of Adjustment. My name is John Kuntz and I'm Vice Chair of the Board. I'll be filling in today for Rodney Swink, who's Chair. The Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the city's Unified Development Ordinance. We are authorized to hear requests for variances from the city's UDO, special use permits, and other requests as may be provided by the city's ordinances. In hearing cases, the board conducts a quasi-judicial evidentiary hearing. That means it is like a court hearing. State law sets specific procedures and rules concerning how this board must make its decisions. The standard the applicant must meet to be granted the request is set forth in the UDO. The board hears and considers evidence presented at the hearing and applies the standard when making its decision. The board must base its decision upon competent material and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. Witnesses may testify as to facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to facts, not opinions. For certain topics, this board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts on traffic safety. Focusing your testimony and arguments on the applicable facts and standard will allow the board to hear cases in an efficient and timely manner. Since today's meeting will be conducted remotely, in addition to the general quasi-judicial rules, today's hearings will be conducted in accordance with the state statutes that allow for remote evidentiary hearings during the current COVID-19 states of emergency. For the convenience of those participating today, I'm going to outline how we will conduct today's remote evidentiary hearings. First, all witnesses must be sworn in. Because of the remote format, individuals who signed up to speak, as well as city staff participants, have already signed a written oath form, which will be reaffirmed in the record as they testify today. The participants also have provided written consent to today's remote meeting. We will begin with a staff presentation from a member of the planning department. Following staff's presentation, the applicant will be acknowledged to present their case and witnesses. The B of A will then acknowledge the attorney or applicant for each case first as the point person for the applicant. Following the applicant, anyone else who signed up to participate in support or opposition to the request will be given the opportunity to speak. The applicant will be given the opportunity for cross-examination as well as rebuttal and a closing statement. When all testimony is complete, we will close the evidentiary hearing. The board members will deliberate and vote on the case. For variance requests, a 4/5 vote of the board is required to grant the variance. For all other hearings and matters, the decision will be made up by a simple majority vote of the board. Following the meeting, the board's decision will be prepared and written findings of fact and conclusions of law. The decisions will be incorporated into the meeting minutes and will be adopted at the same time the meeting minutes are adopted. We will now conduct the evidentiary hearing on today's agenda. All business evidentiary hearing. It is variance BOA 0010-2021. I have that as a continuance request, Catherine.
Yes, the attorney notified staff ahead of this hearing that they would be requesting a continuance. So if you want to call Michael Birch, the attorney, to say that for the record, and if that's correct, then you can continue the case.
Michael Birch.
Yes, sir. Yes, Michael Birch with Longleaf Law Partners here on behalf of the applicant. Yes, we're requesting a deferral to your November meeting. Thanks.
All right, let's put that in the record and we'll continue that to the November 8, 2021 meeting. Thank you. All right, next case, old business evidentiary hearing B, 711 and 713 Grove Avenue, variance BOA 0076-2020. Westover Green LLC and Hussam El Halabi property owners. Let's begin with staff presentation. I believe I need to swear in Eric Hodge and Justin Rometta.
And just a heads up, Justin is out today, so it'll be just Eric.
All right, Eric?
Yes.
You swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Let's proceed.
So BOA 0076-2020 is a request for a 7-foot variance from the minimum lot width requirements set forth in section 2.6.1.D2 of the Unified Development Ordinance for cottage courts They're seeking a 7-foot variance from the 120-foot minimum lot width standard in order to construct a 10-unit cottage court on a lot that is 113 feet wide, comprised of a 1.14 acre property zoned residential 6 and special residential parking overlay. They're doing a recombination with a portion of 713 Grove Avenue to the existing 711 Grove Avenue. So it would be the rear of the existing lot. Let me show the slides. My apologies for not sharing. Is everyone seeing that image? Do you see the PowerPoint?
Yep.
Okay.
Yeah.
So 713 is the lot at the top. Excuse me, 711 and 713 is the lot at the bottom, and they're proposing to take a portion of the southernmost lot at the rear, or the eastern end of the southernmost lot, and recombine that in with the other property to get a configuration more like this. So they're proposing to keep the existing dwelling and then add an additional cottage, as well as 4 additional 2-unit townhome building types to comprise the 10-unit overall cottage court development. As I stated at the beginning, this lot frontage along Grove Avenue falls 7 feet shy of the minimum lot width required for a lot to qualify for cottage court development. The lot, as you can see further back, where they're taking land from the 713 parcel, does widen up to meet that minimum lot width requirement. However, minimum lot width for the purposes of qualifying a lot for various types of building types or developments is actually taken out at the street. So that the front property line, this lot is substandard, and therefore they're seeking this variance request. I don't really have any other comments unless you have any questions of me at this time.
Board, any questions? Hearing none, we'll head to the applicant for the applicant's case.
Thanks, Chairman Kuntz. Can you all hear me?
Yes.
Thank you. Chairman Kuntz, member of the board. I'm Mike Thielen with Womble Bond Dickinson here in Raleigh for the applicant. Thanks for the opportunity. You're going to hear today from a little bit from me, as little as possible. You'll hear from the applicant, which is Westover Green LLC, the managing member of that LLC, and you'll hear from a land planner as well. Chairman Kuntz, with your permission, we're going to toggle between the witnesses, between Mr. Chung, who is the applicant, and Mr. Frank, who is the land planner, so that the slides will proceed in order. And I'll simply come back from one witness to the other, depending on the slide. I'm only going to do that once, but if that's all right with you, we'll proceed out of that order, more or less.
I'm okay with that. Would it make sense to go ahead and swear in the applicants?
Sure.
Is Peyton Chung and Aaron Frank there?
Chair
Bear
Coons.
with me, yes.
Okay, I was just gonna advise, I see Aaron Frank on a separate line, but it sounds like Peyton Chung may be with the
Yes.
attorney, is that correct?
Correct.
Okay, I will go ahead and unmute Mr. Frank right now.
Okay. Mr. Frank, do you swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, and Peyton Chung, do you swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, let's proceed. Thanks.
Thank you.
Mr. Vice Chair, can I interrupt for one quick second? Can we make
Yes.
sure that each witness states their address for the record as well, please?
Okay. Let's do that again then. How about that? Thank you for the reminder. Aaron Frank, please state your name and address.
Aaron Frank,
555 Fayetteville Street, Suite 1100, Raleigh, North Carolina.
All right, and do you swear or affirm that testimony you'll provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Peyton Chung, name and address, please.
My name is Peyton Chung. I'm managing member of Westover Green LLC, which is located at 1133 Manchester Drive, Cary, North Carolina.
And do you swear or affirm that testimony you will provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you.
Thank you, Chairman Kuntz. This is, again, back to Mike Thielen. Ray, if you could switch to the next slide, please. This is for 711 and 713. As you saw, we've got 711 on here as that is the main parcel pursuant to which the variance is sought, although 713 is set to be recombined, that back portion, as you saw, into the property. But the variance would be for the 711 portion to the north, as Mr. Hodge stated for the record. The owner of the property is Westover Green LLC, as I mentioned. That is the applicant. The original applicant in the file is listed as Moonful LLC, of which Mr. Chung is also the managing member, though the conveyance was made at the end of last year from Moonful to Westover. And with that, I'm going to call Peyton Chung to the dais. Peyton, if you could explain to the board your background and your educational and professional background, please.
Yes, could you advance to the next slide, please? Thank you for the opportunity to speak regarding this proposal. My name is Peyton Chung. I am the managing partner of Westover Green LLC. I have 20 years of experience in urban planning. I'm a lead accredited professional in neighborhood development, contributed to the as a co-author for that rating system. Also CNU accredited. I decided to become a developer here in my hometown after a 20-year career in urban planning, because I wanted to set a new tone for a place that I've seen change tremendously over my life. I attended Virginia Tech for urban and regional planning, and also the University of Chicago for environmental studies.
Thank you, Mr. Chung. I would tender Mr. Chung as an expert to the board in urban infill planning and design, please, Chairman Kuntz.
Okay.
I would also at this point move to admit into the record the staff report and all the PowerPoint slides appended, both staff drawn and applicants submitted, please, Mr. Kuntz.
So moved.
Thank you. Mr. Chung, did you submit the original variance application on behalf of the original property owner Moonful?
Yes, I did, and that was last year.
Do you adopt that variance application on behalf of the current owner Westover Green, Mr. Chung?
Yes, I do.
Did you draft the applicant responses to the variance standard as they're contained within the staff report, Mr. Chung?
Yes, I did draft those.
Do those applicant responses represent your thoughts and opinions as an expert in urban infill planning and design, Mr. Chung?
Yes, I do.
Thank you, Mr. Chung. Would you please take us through the project?
Sure.
Ray, if you could move to the next slide, please. Thank you.
Yes, thank you. Here's a photo of the existing house at 711 Grove. It was built in the 1960s, and we intend to, it's 1954, and it's a ranch house on a double lot, just shy of 1 acre in size, in the Sunset Terrace Extension neighborhood on the west side of Raleigh. We do intend to retain this house on the site if the cottage court variance is granted. Next slide, please. Here's the 711 Grove Avenue site that's been highlighted on a parcel map of the block between Grove and Powell. You'll notice that this block is exceptionally deep. Our lot is 385 feet deep. It is a double wide block. There's a dead end street to the north that was not continued that was built as part of the original Sunset Terrace, closer to Western Avenue, but not extended into Sunset Terrace Extension, perhaps because that was done in 1935 in the depths of the Great Depression. The next slide, please. As you can see, many of the lots in Sunset Terrace Extension, the 711 Grove lot is a double wide lot, and the ones to the south were single wide lots as of the 1935 plat. Many of the other lots were combined, like 711, to create wider parcels, and when possible, they were often recombined or split down to create shallower parcels like those on Linville Drive. On the block to the north, on Powell, there are some existing 1935 original lots that only have houses in the back of the lot, not as well as other houses in the front. So there were lots on Powell Drive, one block to the north, that were split east-west, with the assumption that there would be some kind of access to those landlocked rear lots. I believe 616 Powell is a remaining example of a lot that has no street access other than through the parcel to the front. Again, that was existing as of the 1935 original plat of Sunset Terrace Extension. Next slide, please. Many of the other, as Mr. Hodge noted, this area is zoned R6, and many of the other parcels around have in the past, under previous UDOs prior to 2012, built up to the 6 units per acre density allowed in this area, with either attached houses, duplexes, triplexes, or apartments. And the surrounding parcels that are built to those densities, which cannot be done under the UDO from 2012 until 2021, are highlighted in yellow. Next slide, please. But the predominant land uses surrounding this site on three sides of the site, in fact, are townhouses, which between 2012 and 2021 were considered non-conforming by the UDO because these are no longer allowed in R6, and the private streets that are shown to the site's north and to the site's east also were not allowed. Next slide, please. This particular lot has an odd shape, which we'll come back to in a little bit. But by and large, it is a very it's an unusually deep lot for its width. Again, it's 113 feet wide and 385 feet deep. We believe that this is that this is an excellent site to be able to use a cottage court layout, which previous planning staff reports had identified as appropriate for remnant sites. The L shape of the lot is due to the recombination that we have pending that I've already filed. We're purchasing the back third of the half-acre lot at 713 Grove in order to create this L shape. We did this as a way of addressing staff's earlier concern from 2020 when we first filed this variance. That the layout on the 711 lot alone did not provide enough of a common centered courtyard between units. By purchasing the 1/6 of an acre at the back of 713 Grove, we're able to rotate some of those units around to the side and have 6 units, the majority of the 10 units on this site, facing across a common centered courtyard from one another, with the other units still facing either a meandering courtyard that connects that centered courtyard to the street, or Grove Avenue itself, which is and having units facing the street is also a goal of the city. I believe that this particular layout fits very well within the context of context that surrounds us. Like I said, many of our neighbors are existing attached houses, duplexes, triplexes, and townhouses that surround parking courts. I believe that the city is on the right, had the right idea with passing TC 618 in order to promote the use of cottage courts, so that units focus on garden courts instead of parking courts. These will be small house-sized structures that are in line with about 1,100 square feet per unit. That is broadly similar to the 1,300. Okay, next slide, please. That are broadly similar to our neighbors who average about 1,300 square feet. Again, almost all of our neighbors here are in 2 and 3 unit. Are in 2 or 3 unit or townhouse buildings. These houses will be attainable for middle and moderate income families in the Raleigh area, this is in contrast to some of the other infill housing that's been built in the neighborhood in recent years. The sole reason this design that we've proposed meets every other dimensional standard for a cottage court, substantially exceeds many of them, in particular with regard to open space, except for the site width, for which we are off by only 6%. The next slide, please. There are a couple of, as the staff report mentioned, there are other by right development options for the site. Again, I've proposed a cottage court, which would be 10 small houses around a garden courtyard. There is a conventional development approach where we could reuse the existing 2 lots, paper lots that are on this property, construct a very large detached or attached houses with garages facing the street, demolish the existing house, and leave those with large rear yards. There have been several instances of developers taking advantage of the fact that the original 1935 plat had these very narrow and long lots and placed very large houses upon them. The third development option, conforming development option for the site, now legal under TC 520, which was adopted subsequent to the filing of this variance request, would allow 11 townhouses on this particular site without any variance whatsoever. They would face a private parking lot, and that would require, again, demolishing the existing house. Back to you, Mike.
Thank you, Mr. Chung. Chairman Koontz, I would call Aaron Frank to the dais, please.
Okay.
Aaron, can you describe to the board your educational and professional background, highlighting your time as a municipal planner in multiple jurisdictions, please, sir?
Good afternoon. I'm Aaron Frank. I'm a land planner with Womble Bond Dickinson, and my educational background, I received my education with a bachelor's of geography from the University of Mary Washington, as well as a master's of urban and regional planning from Virginia Tech. In short, with my professional background, I have worked in municipal planning departments, and in doing so have administered development applications and worked on small area and long range land use planning in Chapel Hill, North Carolina, in Peoria, Arizona, as well as in land use and development policy and practice for the Fairfax County Board of Supervisors in Northern Virginia. I am AICP, American Institute of Certified Planners, certified. Thank you, Mike.
Thank you, Mr. Frank. Chairman Koontz, I would tender Mr. Frank to the board as an expert in municipal planning, sir.
Okay.
Thank you. Mr. Frank is going to begin by testifying to this first standard that we are here to address, and that we would marshal the evidence in support of, that unnecessary hardship result from the strict application of the ordinance to the project as proposed. I consider this a form of a function standard. And we'd also categorize this as not only hardship, if you read how the ordinance is written, it's not just hardship to the applicant, but it's also hardship to the neighborhood and to the community at large with the strict application of that 120-foot lot width standard to this cottage court concept. Mr. Frank, are you familiar with the application for the variance as it's been submitted to the city?
Yes, I am.
In your opinion, Mr. Frank, does a strict application of the ordinance requiring the 110 lot width to applicant's cottage court project result in unnecessary hardship to the applicant? Excuse me, the 120-foot lot width to the cottage court project result in unnecessary hardship to the applicant?
Yes, it does.
In what way, Mr. Frank, does the strict application result in unnecessary hardship to the applicant?
The strict application of the ordinance it results in a hardship to the applicant in a few different ways. Firstly, retaining the existing single-family dwelling on the entire lot is an inefficient use of land, given that it's a relatively large lot size for the single house that exists. The property before us, it's not virgin land, and surrounding properties have redeveloped to make better use of the land within this neighborhood. That there are city policies and market trends that support a higher use of the land, and a single family as currently exists wouldn't be the highest or best use, and particularly even with respect to neighborhood compatibility. Should the property be developed by right, it would likely be townhomes. That requires demolition of the existing house, whereas the cottage court allows for incorporation of that existing house in its design. So that allows for housing preservation, which is important for a few different reasons. Housing construction and demolition, for that matter, consumes a lot of energy with the manufacturing, construction of all the materials that have been constructed within the existing house, and then would be going to the landfill with demolition, and then required again with new construction. But also from a neighborhood context perspective, the cottage court allows for preservation of the house, which retains community character. And this is noted as a goal in the comprehensive plan, as well as preserving houses can foster the stewardship of neighborhood, place, and landscape as the city grows and develops, and that's noted in Comp Plan Policy 1.1. We're also seeing, from market trends and the city's policy direction, as I mentioned earlier, that additional housing quantity and types are needed across the city, and particularly in this area. Projects located near the future Western Boulevard, BRT, or bus rapid transit, and the city is planning for additional residential density around those. The comprehensive plan talks about transit supportive design, even providing missing middle housing, which the cottage court is a housing type of. In these to be proposed in nearby residential areas in 8.3 and 4.19 of the comprehensive plan. And as Mr. Chung showed in the previous slides, the surrounding context of the neighborhood supports this type of dwelling, as there is a mixture of housing types, such as townhomes, duplexes, triplexes, and apartments in the neighborhood. I'd also note one more thing, that the variance itself is a function of the lot, not the design of the cottage court. So it's not as if a different design of this cottage court style development on the property could solve the variance that is being applied for. A cottage court can be appropriately developed within the 113 feet lot width, as seen by the site plan, and other city requirements are satisfied, but demonstrated also that cottage courts are permitted within even narrower lots in other zoning districts. So it's not that the cottage court necessitates this amount of land, but rather that the applicant does not have the ability to expand the lot width to meet this standard, although the applicant has made efforts to consolidate with the adjacent property owner for the back half of the lot. So there's several hardships to the applicant. Thank you.
Thank you, Mr. Frank. And in your opinion, does the strict application of the ordinance result in an unnecessary hardship to the neighboring landowners, sir?
Yes, it does. With the variance, the proposal provides a landscaped community open space as part of the cottage court that would be lost without a variance. Townhome development is permitted by right, although it doesn't have the same open space requirements as a cottage court. And this would be a hardship to the neighbors in that the cottage court proposal provides about double that of a by right townhome development in open space. The open space with the cottage court allows for effective stormwater management and good design with greater green space and an internal community feel with the central courtyard. Retention of the single family home, should it remain in its current status, or the redevelopment of the townhome community, wouldn't accomplish this. And similarly, it's not consistent with the hybrid context of land uses within the surrounding area. Between the redevelopment with some new units, as well as the preservation of the existing house, it kind of allows for the best of both worlds in some way, where you have the preservation of the existing house facing the street with attached and detached single family in the rear. This supports a few different comprehensive plan policies, such as Historic Preservation 1.1, Stewardship Place, Housing 1.1, Mixed Income Neighborhoods, 1.6, Housing Preservation, 1.8, Zoning for Housing, and 15, Scattered Site Infill. Thank you.
Thank you, Mr. Frank. And what about the strict application resulting in unnecessary hardship to the community? Do you have an opinion on that, Mr. Frank?
Yes, I do. I'll also note something for you and the board. And there's that I understand that there are members of the community who did register to sign up to speak. But as far as my opinion goes, cottage court type of housing, is something that is desired by the city, explicitly so in the comprehensive plan to provide affordable housing, and also explicitly in recent text amendments that have made it easier to provide cottage courts in TC 618 as well as TC 1B20 text amendments. There are several applicable comprehensive plan policy statements, 2.2, 8.1, 1.8, and 2.8, which are noted as supporting these text amendments that have expanded the zoning districts where cottage courts may be located. It also modified the development standards to facilitate construction. So, while the city is incentivizing the cottage court type, we do recognize every lot is unique, and it wouldn't be possible without a 6% variance at this location. What that variance would do would provide additional housing stock at a compatible scale, which is in line with future desires for development across the city. There would be stormwater management and open space, community benefits that are not required with by right development. The central courtyard is a hallmark of the cottage court design, promoting a sense of community. And the applicant here is unique in that the applicant wants to go ahead and build this product type, which isn't necessarily easy to do given the ordinance standards compared to other development types such as townhomes.
Thank you, Mr. Frank. Chairman Koontz, I would excuse Mr. Frank for the time being, and I would call Mr. Chung back to the dais.
Granted.
Ray, can you switch to slide 13 is what it's numbered for us, the go back to from where you are now? Perfect, right there. Thank you, sir. Okay, Mr. Chung, did the hardship described in the application materials and in Mr. Frank's testimony that you just heard result from conditions that are peculiar to the property?
Yes, Mr. Thielen.
Can you tell us how so?
Yes, the existing 711 Grove lot is 113 feet wide. It was a remnant from a prior subdivision where all lots were about 56.5 feet wide. All of the other lots that are remaining as single-family detached houses in this neighborhood have at least 120 feet in width in the front. Therefore, this is the only lot within Sunset Terrace extension that would require a variance in order to construct a cottage court. It is also located between several non-conforming, now non-conforming multifamily structures, in particular the townhouses that surround it, which do not provide any available street accesses to the center of the block, and therefore to the majority of the site's usable area. This is unlike one block over to our west on Carolina Avenue, where where the street was extended over time in order to create a mid-block access that allowed the lots on that side of Sunset Terrace Extension to develop in both to their full zoned capacity. Again, also, I would note that the location of the existing house on the lot is up at the up towards the front of the parcel, but also straddling the old lot line. This could be preserved only by a cottage court design because there's insufficient width on either side of the house to fit a new street in for townhouse development. In seeking to preserve the context and character of the neighborhood with this particular house, that we would not be able to retain this house. We'd have to demolish it and replace it with other structures that would likely not fit into this neighborhood context.
Thank you, Mr. Chung. Ray, can you switch to the next slide, please? Okay, Mr. Chung.
Yes.
Can you go back one slide, Ray? Thank you. Thank you. As the applicant, were there any actions that you took that caused this hardship that is created by the strict application of the ordinance?
No, Mr. Thalen, I did not cause this particular hardship. The lot width of 113 feet along the front is pre-existing. Again, it dates from a 1935 plat for this subdivision. And that was long before not just the 2012 UDO, but many other zoning ordinances before it. It is a immutable property that is outside of a property owner's control. The particularly deep shape of this lot, I'd note that this one lot is deeper than an entire downtown Raleigh block is wide. It makes it very difficult to use the available density that is on this site, which either a cottage court or a townhouse layout would be able to maximize. But again, we think that for various reasons, the cottage court layout is superior. Adjacent non-conforming lots like the triplex a couple doors to our south or the townhouse courts surrounding us utilize internal private streets that the 2012 UDO does not allow us to do. We think that having a public alley is a superior approach that hopefully means that that in the future this block will not face similar problems with regards to excessive block length and poor connections for the street network. Mr. Thielen, any other questions?
No, Mr. Chung, thank you. Chairman Koontz, I would call Mr. Frank back to the stand.
Granted.
Thank you. Ray, can you switch to the next slide, please? Thank you. I will note that there is a note on here about opposition. Chairman Koontz, we know folks have submitted up and folks are present here to speak as to the variance request. At the time these slides were submitted, though, there was no indication anybody had signed up, nor was there any indication of opposition. I don't know if those are opposed or to what degree, but I did want to make that note on that second line there, that there may in fact be opposition since the submission of this application and these slides to the board.
Understood. Thank you.
Thank you, Chairman Koontz. Mr. Frank, in your opinion, is the variance sought consistent with the spirit, purpose, and intent of the city's UDO such that public safety is secured and substantial justice is achieved?
Yes, I do. And
can you tell us how, in your opinion?
yes. So when I reviewed this application I did so, through the planning lens of looking at the city's UDO and the comprehensive plan. And I'll try to be brief here because if I were to rattle off every single UDO standard and comprehensive plan standard, we could be in for a long hearing. But I look at the purpose and intent statement of the UDO, and the first intent statement in that section 114 is to implement the policies and goals contained within officially adopted plans, including the comprehensive plan. So naturally, I go to the comprehensive plan. But there are other UDO statements. Improve the built environment and human habitat to ensure that new development conserves energy, land, and natural resources, provide neighborhoods with a variety of housing types, to serve the needs of a diverse population, and to encourage compact development. And I see that the application is consistent with each of those UDO intent statements. When I look to the comprehensive plan, I see that the Cottage Court supports several policies. From a land use perspective, the application meets LU 2.2, 419, 5.1, and 8.1, which address compact development, providing missing middle housing and housing variety, respectively, by accommodating growth in a variety of different housing types. The Cottage Court development type is a form of missing middle housing. And it also satisfies 5.1, reinforcing the urban development as it acknowledges some of the existing buildings and new development is implemented without adverse impacts on local character and appearance. The proposal also meets housing sections, 1.1 mixed income neighborhoods, 1.6 housing preservation, 1.5 scattered site infill, 1.8 zoning for housing, and 2.8 accessory dwelling units and cottage courts, as well as 1.1 stewardship of place, as we mentioned earlier about that housing preservation. These goals are being met through preservation of the house, fostering stewardship of neighborhood, as well as the desired type of that cottage court housing units type being provided. There are also goals related to transit and locating missing middle housing in nearby residential areas in urban development 8.3. As mentioned, this site is close to the Western Boulevard bus rapid transit and provides some natural synergies with providing housing density of a compatible scale in places that are walkable or bikeable to alternative transportation. I also note that larger lot width variances have been granted for cottage court designs in a prior case, BOA-0067-2020. And of course, that's a different case, but I did note it, and that this variance before the board this afternoon is de minimis. It's 7 feet or 6% off the lot requirement. I note as earlier that all of the elements of the cottage court can fit in a smaller footprint than the 120-foot required lot width. Cottage courts are allowed in much smaller lots in other districts. And the proposal does meet all our city standards while providing superior design from other development types that could be constructed on the property. Thank you.
Thank you, Mr. Frank. And with that, Chairman Kuntz, I'm going to bring back Mr. Chung to the dais to take us through the final portion here, which will be brief. I appreciate the time.
Yes, thanks again for your patience, and thanks, Mr. Thielen. Next slide, please. As Mr. Frank mentioned, this particular site is within 1/3 of a mile of two bus rapid transit stations that have been proposed for the Western Avenue BRT corridor. This is a slide from the a graphic from the city plan, city urban design office's plan for this particular corridor, showing with our site highlighted with the gold star there. As you can see, there are retail and high density residential options all around this site. There are there's a shopping center that the city has identified as a future mixed use node, and we are within walking distance of that site. Next slide, please. This particular variance fits very clearly within the spirit and purpose of the UDO. This is a minimal variance that enables a housing type that the city has stated that they would like to see more of within the city. It is consistent with the spirit, purpose, and intent of the UDO. And very much in keeping with the spirit of the updated comprehensive plan. Next.
Thank you, Mr. Chung. To the next slide, please, Ray, and to the final slide of our presentation. Thank you, Mr. Again, Mr. Kuntz, and the members of the board. At this point, we would close our case in chief and ask the board to request or to grant the application for the 7-foot variance as requested here in this slide, and as stated by the staff report. And with that, we would reserve the right to cross-examine and also the right for rebuttal if necessary. And that concludes our case in chief.
Thank you, Michael. Let's see, we have some opposition speakers for the case, and I have the first one here is Perryman, Peyote Perryman.
Yeah, good afternoon.
Okay, let me get you to state your name and address in relationship to the case, and I'll reaffirm your oath.
All right, my name is Peyote Perryman. I reside at 1000 Ravenwood Drive, south of the property in question here.
Okay, do you swear or affirm that testimony you will provide will be the truth, the whole truth, nothing but the truth?
I do.
All right, proceed.
Thank you very much. This is the first time I've had an opportunity to ever speak before a Board of Adjustment. And my background really falls more in a video production. I run a television production company in downtown Cary. I did work for the town of Cary in the Public Information Office many years ago and got to sit through a lot of meetings and then was a member of the West CAC up until the time that it was dissolved and was able to vote on issues important to the neighborhood. So I appreciate the opportunity to be able to address the board and provide you my input. I'd like to really just talk about the planning design as presented by the applicant in this matter. We've seen another cottage court come into our neighborhood recently. It was on a much larger lot, and I felt like that it fit more in the spirit with what the city is trying to accomplish. So if I look at this L-shaped piece of property that the applicant is trying to get the variance for, I find it hard to call the lot 7 at the back a central common courtyard. And I feel like you've got a long row of houses with a rear courtyard. And I also would say that the desire to not demolish the existing house to try to keep with the character of the neighborhood, the portion of Grove that this is going to be developed, has a lot of different housing product, as pointed out by the applicant, by his counsel. So I don't know that preserving one house to put up 5 more or 4 more duplexes around it is necessarily preserving the character. And I think you could almost develop this better by demolishing it and starting over with a clean slate, in my opinion. If you look at our neighborhood in general, you see smaller houses being torn down and various houses being built up. And sometimes they're large houses, sometimes they're skinny houses, but they all have been able to fit on the lot sizes that they have available to them. I would think that there would be a product. In fact, the staff report said that there are options, and the applicant has said there's options for developing this that wouldn't necessarily have to be a cottage courtyard, that would allow for increased density and be perfectly applicable. The idea of the UDO and the city wanting to promote walkability, I think is a great desire, and I appreciate that as a person who walks in my neighborhood all the time. That portion of Grove is a little bit more dangerous because there are no sidewalks. I can walk down the street, and if I go all the way to Scarlet Maple, I've got a sidewalk and then it ends right there. I would be curious as to why there's an interest in promoting walkability while at the same time the applicant has created more parking than is required by the UDA, which you'd only would need 10 parking spaces for 10 houses. And I believe, according to the site map that I could read, it looked like there's 17 parking spaces. And I don't know that there's going to be a lot of room for a sidewalk, even though there will be a right of way for that sidewalk. It's been my understanding that most of the time developers will just pay in lieu of a sidewalk and wait for the neighborhood to petition for one later on down the line. And if there's anything that needs its sidewalk, it would be Grove all the way to Western. And so the other portion of this is kind of that you've got two street, on his application, he says he has two street facing houses with 8 houses around a rear courtyard. But that would only be 2 rear front facing houses if you count the lot that's not part of this lot. So the 713 duplex would have to be considered part of this courtyard, but that isn't part of this plan. So I don't know how you can call that 2 front facing homes when you really have only got the one that's on this lot of 711. So I just wanted to point that out. And one of the things that really has been important to me, because I live downstream, is stormwater management. And I've met with Raleigh Stormwater Management Division about the White Oak Lake project when it was abandoned, and the culvert there at Ravenwood that has been slowly filling up with silt from projects upstream of it. And I'm curious as how this bioretention area at the front of the lot, how that does not increase the stormwater runoff into Grove Avenue or directly to the south into 713 Grove. Again, it seems like to put your bioretention out of the street seems like an odd choice to me. And the last point that I'd like to make is just that the applicant is looking to create a different housing type, and I don't think this lot supports it. I would actually have no problem with townhomes going in here because I appreciate increased density, but I feel like this is creating a bit of a little bit more of a hard I don't know, with the dogleg street going in, to me, it seems like it creates more traffic problems than it solves. I think a center parking lot for townhomes would be much more easy for the coming traffic that's going to happen along Grove Avenue as more of these lots get developed to higher density. And with that, I'm finished opposing.
Thank you, Mr. Perryman. Any board questions for Mr. Perryman? Hearing none. Any cross-examination from Mr. Thielen?
No, thank you, Chairman Koontz. Thank you for the information, Mr. Perryman.
You're welcome.
All right, next for in opposition, Ted Shear. Is Ted in?
I'm here. Good afternoon. I'm Ted Shear. I live at 928 Ravenwood Drive. This is actually the same street as Grove. The street's only 4 blocks long, but the name changes right in the middle. So I live.
May I swear you in real quick, please?
Oh, yes, I'm sorry.
Yeah, that's fine. Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right, proceed. Thank you.
Okay, so as I said, I live at 928 Ravenwood, same street as this one with a different name. I live next door to Mr. Perryman, who I think gave you some good insight into some of the planning issues here. I'd like to speak directly to the hardships here. The standard for a variance from the Board of Adjustment is that there are practical difficulties or unnecessary hardships in the way of carrying out the strict letter of the ordinance. And there are 5 general rules used to determine if there are practical difficulties or unnecessary hardships. And the first is that the property owner can secure no reasonable return from or make no reasonable use of the property. But as been reiterated by city planning staff in their report, there are other uses of this property, other uses that do increase density and allow as many or more units there. The second is that the hardship results from the application of the ordinance. The third is that the hardship is suffered by the applicant's property. But I would claim that there is really no hardship resulting from the application of the ordinance. I can't even see how this is a cottage courtyard. The applicant said, well, 6 of 10 of the houses sort of face a central courtyard. But if you look at this design, 5 of the 6 structures are lined up along the driveway. They did move one to the back of the neighboring lot on 713. But if you look at the design, the preliminary site plan, which has no legal ties to this, any finding you have, at best, you would call the 3 units, the 2 back units on 711 and the back unit on 713 as 3 units that look out into a little courtyard. And the rest is just the area between the other houses and behind the houses. If you look in the UDO, the examples of courtyards don't look like this. The houses all face the courtyards. That's the whole idea. And this does not seem to meet those design standards. The fourth standard for a hardship is the hardship is not a result of the applicant's own actions. And so any hardship this applicant claims is directly the result of his own actions. This is the classic case of Aberdeen Garage versus Murdoch that's outlined in Browen Green's The Zoning Board of Adjustment in North Carolina. By the way, I've read that book many times because I spent several years on the Board of Adjustment, so I'm familiar. I've seen it all, let's say. And in that particular case, the NC Court affirmed that, and I quote, "It would not require any great stretch of the imagination to say that the petitioner purchased the property with the thought in mind of making the present application. Consequently, it cannot be well contended that the restriction imposed by the zoning ordinance caused the petitioner a particular hardship that entitled it to the special privilege it seeks," end quote. I don't know how the 2 properties fit together. We don't have the representative of 713 Grove here. I don't know if the applicant has an option to purchase that. If he does, then again, from Browen Green's book is Lee versus Board of Adjustment, where Lee took an option and then sought a variance. And the North Carolina Supreme Court ruled, and I quote, "An option in relation to land grants the right to elect with a stipulated period to buy or not to buy. The applicant optionee merely has the right of choice granted by this option. He possesses no present right to erect a building on the lot described in his contract. To withhold from him a permit to do what he has at present no right to do cannot in law impose an undue and unnecessary hardship," end quote. It's hard to determine how this applies to him because we studied this case before the prior meeting where we were sworn in to attend that meeting. So they've known for at least a month that we were here to be opposition. It shouldn't have been a surprise. But if the 2 owners were to combine the 2 lots rather than fully splitting off a third of one of them and leaving the rest, then they could build a cottage courtyard by right, but they choose not to do that. And thus any hardship that results here is directly the result of the applicant's own actions. Now, the expert witness, Mr. Frank, does try to make the case that this is a hardship on us, the neighbors. I would say the applicant and perhaps his expert witness doesn't know the neighborhood and doesn't know the neighbors. And it's actually quite insulting to the neighborhood for them to tell us what we need and what's good for us. We support increased density. We support the UDO, but we even support cottage courtyards when they're done well, and we have them going in our neighborhood. But this is not a cottage courtyard. And the final standard is that the hardship is peculiar to the applicant's property. And that's not so. The applicant himself claims that the hardship is due to conditions that are neighborhood-wide and not peculiar to his property. The applicant argues that if only the neighborhood had been designed differently, he wouldn't have to seek a variance. It reminds me that just a couple of weeks ago, President Trump tweeted out that Robert E. Lee, except for Gettysburg, would have won the Civil War. Yeah, well, except for the greatest generation, Germany would be the only company in Europe, and except for my poor choice of parents, I would be tall, slim, handsome, and wealthy, but I'm not. This is how the neighborhood was laid out intentionally, and it's not a peculiar nature that this property. But in any case, that kind of relief is a matter, of changing planning designs and standards. And the spirit intent of the UDO as we speak to that, that's not the issue here. The UDO is the matter for the local legislative body, the city council, and not of the Board of Adjustment. So the applicant fails to meet the required findings for issue of variance. There are no practical difficulties, just full stop. And without a hardship, there is no basis for the Board of Adjustment to issue a variance. Mr. Perryman refuted some of the claims of the applicant that his request is simply good planning. But even if the claims were sound, if either the applicant or the members of the Board of Adjustment are concerned about planning issues that have been raised, then they can either, one of them or both together, can go to the city council and ask that the UDO be modified. This opportunity to appear before the board exists to provide relief from hardships that are imposed by the zoning, not to modify, reinvent, reinterpret current zoning law to promote the particular planning goals of the applicant. And in this case, the applicant fails to meet the required findings for issuing a variance. And I think with that, I'll end my comments.
Thank you, Mr. Shear. Any board questions, Mr. Shear?
Mr. Coons, can I make one quick point of clarification for the board members? The current Board of Adjustment variance standard, which is set by state law, is in your staff report for each case. There's 4 hardship standards, and those are the standards that you're applying today. One thing I did want to point out, just because it goes to the legal standard by state law, the first standard states that it's not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. So to make sure you guys are clear on what that standard says. And then on the third one, state law says that the act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship. So just want to make sure that you all have the correct variance standard to the extent there was any questions about what the standard you're applying might be. And if you have any questions about that, free to help you with those.
Thanks, Catherine. Any board questions of Mr. Shear? Mr. Thielen, do you have any questions or cross-examination from Mr. Shear?
No, I do not, Chairman Coons. Thank you, Ms. Hill, for the clarification of those standards. I appreciate it. And thank you, Mr. Shear, for the information.
Last opponent, Donna Newman.
I'm here. Thank you.
Would you please state your address in relationship to the case?
My name is Donna Newman. I live in 710D Powell Drive, which is the part of the back building on Powell Drive. Right behind.
I'm sorry.
Can you hear me?
Yes. Do you swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, proceed.
Okay. So I live in the Ashworth Towns complex right behind the property. My education is undergraduate from Chapel Hill in biology and a PhD in biochemistry from North Carolina State University. And I've lived in my property for 20 years and was the HOA president for 6. And I appreciate the comments made by the other 2 previous opponents of this project, and I agree with them. But I would like to add a few words I hope you'll find a bit different and possibly compelling. In the variance petition case report itself, the staff response to the variance standards on point 2 says in effect that the minimum lot requirements were established so that developments can be, and I quote, sensitively located within existing residential neighborhood contexts. And I hopefully will argue that the project as planned would not be a sensitive addition to our neighborhood, but would instead result in the destruction of a locally valued green space and drastically reduce the capacity of the property to absorb rain. It would also increase the vulnerability of the Ashworth Towns townhouses to physical damage and our residents to increased crime and the loss of privacy. Woods at the rear of the 711 and 713 Grove Avenue property help give the neighborhood its character rather than the house that is planned to be saved. It's a shady, walkable, and wooded natural area. The woods in the back stabilize the soil and absorb rain, reduce muddy runoff down to Lake Kramer, which is on Ravenwood. And the nearby clear cuts of recently developing properties may have increased such runoff so as to require the lake dredging. I think the previous two speakers would be able to attest to that better than I. But the woods also provide wildlife habitat and a corridor between Powell Park to the south and Jackson Park to the north. Given that trees in a forest weave their interconnected roots that stabilize individual trees and protect them from blowdown, removing the woods along the property line would damage the roots of trees on our property line and would leave several of our homes vulnerable to blowdown of large trees on our property that have so far been protected from the wind. The woods at the rear of the property also give us privacy and protect us from foot traffic through our backyards. We have no fence there. A public alley and the road along the rear property line would allow direct access into our backyards and leave us vulnerable to increased crime without increasing community interconnectivity at all. Now, I don't know what the coming plans for the bus transit actually hold for interconnectivity of streets in our area, but like one of the previous speakers mentioned, this lot size was planned before, and we've always had this green space in the middle. Although it's been cut down and regrown, it's always been not built upon, other than several single houses. As I read the UDO section 8.3.5, D5 subsection A, the cross-access requirements were described as described in section 835D shall not apply when abutting property to which the driveway is to be stubbed is in a residential district or occupied by an attached, detached, or townhouse building type. And B5B V states that such a stub would be obstructed by, among other things, open space, which I don't know how the city defines that, but I can see how woods would also be open space. And the planned development would increase the vulnerability of Ashworth Towns to physical and aesthetic damages. It would further dissect another of Raleigh's naturally wooded areas, and it would set a precedent that could lead to the eradication of the entire stretch of natural green space between the parks. Therefore, I ask that the board reject this variance request for cottage court on this too narrow plot that would both require a rear road at the lot line and adds to the referred to precedent of eroding development standards set only recently by the city. I ask the developer to consider instead an alternative that would spare a significant, meaningful depth of intact woods at the rear lot line of the property and would provide more actually affordable living choices for people who need access to modestly paid local jobs and would benefit from the planned improved bus transit upgrades. This would be more in spirit of the current path for affordable infill housing in our city of Oaks and still retain the wooded character of the Sunset Terrace neighborhood. Thank you very much.
Thank you, Mrs. Newman. Any more questions, Mrs. Newman?
For me, or?
Frank, any more questions for you? Hearing none. Mr. Thielen, any cross-examination questions?
No, we have none, Chairman Kuntz. Thank you. And thank you, Ms. Newman, for the information. I will reserve, we have no rebuttal, Chairman Kuntz, but we would have a very brief closing.
All right. You can proceed with the closing now.
Thank you, Chairman Kuntz. I'll keep this brief, members of the board, city staff as well. We appreciate all the time and attention to this matter today. I don't have to remind the board that this variance today is not about the actual design of the product itself, but this is about the four legal standards that Ms. Hill outlined and that are outlined for you in the staff report. And the design, of course, has to and will meet all city requirements for access, for stormwater retention, and filtration, and so on and so forth. The ordinance itself, the 120-foot lot width, like any city ordinance, is well-intentioned, and it has proper application in many contexts, but it is not a one-size-fits-all. As you heard from the folks from the community who did speak about this project, This is a unique neighborhood. There is a demand here for density and an appreciation for density. And this is in fact an option, the variance itself, for some relief with a strict application of the ordinance as to those properties where the ordinance application does not make 100% sense. And so with that, Chairman Coots and members of the board, we would again request the board grant the variance from the 120-foot lot width to the 207 feet for a 113-foot wide lot for these properties pursuant to the application as submitted and without conditions. Thank you, Chairman Koontz.
Thank you, Mr. Thielen. Staff, you have anything to add?
No, not at this time. Thank you.
Thank you. Any board questions of the applicant or the presenters? I will close the evidentiary hearing on that note, and let's move to board deliberations, or I'll entertain a motion. Let me clear one thing. Ms. Riddlesell, I know you're on. Were you here for the entire presentation, or are we still with Michael Rainey?
No, Michael Rainey would.
Okay, thank you. All right, so Michael, you're voting on this one, and then we'll entertain Ms. Riddlesell thereafter. Board deliberations. Mr. Pacini?
Yes, sir. Ms. Ruder, so what time did your video end? I could not see you when the presentation was up.
About 150.
About 150. Thank you. Thank you. Thank you, Mr. Chairman.
Okay, thank you. Any deliberations, or I'll take a motion from someone.
Don, this is Michael. The only comment I've done is I'm struggling with the hardship factor in light of the other development options. I'm just not sure that I'm seeing hardship. We have other existing options based on the property as is. I'll throw that out to the board.
Can't hear you, Michael.
Okay.
There you go. A little better. Yeah.
Is that better?
Yes, better.
The concern, or what I'm struggling with, is the hardship element. In light of the evidence that, as currently configured, there are other development options, multiple other options. So I would like to hear from the rest of their board as to their thoughts on that issue.
Marvin, have any thoughts?
Yeah, I mean, Catherine indicated, I think under item or number 3, that when an applicant purchases property, meaning that they could, can you explain that again, Catherine, about the hardship that you spoke of? Could you read that comment again for the?
Yeah, sure can. I'm just reading straight from state law, what the standard says, which is that, I'll read the whole standard. The hardship did not result from actions taken by the applicant or the property owner. The act of purchasing property with knowledge that circumstances exist that may justify the granting of a variance shall not be regarded as a self-created hardship.
So basically, this is not a self-created hardship, is what you're basically saying by purchasing this property, that because I think it was Mr. Spear or Shear who indicated that the applicant is creating the hardship on themselves. Is that correct?
I think the intent of the standard is that if you buy a piece of property that requires a variance to be developed, that you're not prevented from seeking that variance because you knew that before you bought it.
Okay, so it does not prevent you from seeking the variance. Okay.
Yeah, I don't know that now. If you have questions about moving a property around and all that kind of stuff, I mean, that might be a different circumstance. But I think this is just intended to say there's other ways you can create a hardship, a self-created hardship, but strictly purchasing property knowing that you would need a variance to, or that there might be circumstances that justify a variance, that alone does not prevent you from seeking one.
Gotcha. Okay, makes sense. Okay. And like Michael, I too was, has been mentioned that there's other options available for this property. And I think one of the applicants indicated that I think townhomes would be a fit here. And also according to what Eric Hodge mentioned also about there's other options in his opening statements as well. And I'll just hear from anybody else as well.
Yeah, this is Steve Kenny. I also have trouble seeing a hardship here. In the past, with granted in these situations was neighbors, but it seems we have some opposition for the neighbors here. And so I really just don't quite see the hardship.
Thank you for everybody contributing. I think it's a tough case for sure. I think you know, you can listen to one side and the other, and as much as I think the city, and as much as we'd like to get behind the cottage concepts on, you know, I'm wondering if this really is the right fit there. But I'm not a planner either. But you know, I respect and I understand the ask. But like the three I've just heard here on the board, you know, I'm inclined to say no. You know, given other options there, you know, given the hardship of the property, or the hardship that they're representing, that's where my head is too. So, you know, if there's someone else that can make a motion, I'm happy to entertain it. Or if you want to talk more about it, that's fine too.
I guess I'll, you know, since what I'm hearing is that I'll make a motion to deny the case.
I'll second that.
Today.
Okay. We have a motion to deny, and Michael Rainey seconded.
All righty, calling the roll, please, on the motion to deny.
Yes.
Mr. Kenny? Your vote?
Deny.
Thank you. Mr. Rainey?
I approve the motion to deny.
Thank you. Thank you. Chairman Coons?
Deny.
Thank you. Let's see, Mr. Butler?
Deny.
I had you already, I'm sorry. Mr. Sutton?
Deny.
Thank you. Who's left?
I believe that's it.
4? 4, okay, that's 4 votes, yes, sir.
That's 5.
That's fine.
I
Yeah,
had-
yeah, 5.
Kenny, Rainey, Coons, Butler, Sutton.
Yeah.
Thank you, sorry. This one, thank you very much.
Yep. All right. Mr. Riddlesole, you're going to take it from here for Mr. Rainey. Is that correct?
Yes.
Everybody else is in place as it is. Okay. All right. Let's move on to our next case, which I have it as new business BOA 0044-2021, 4401 Auburn Church Road, Duke Energy Progress LLC is the property owner. That's right. Yeah. Okay. Let's go. Justin, do I need to swear you in?
Yes,
Okay. Do you swear or affirm that testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Proceed. Thank you.
All right, thank you. I'm gonna set up my slides. Are you all seeing those?
Not yet.
Let's see. All right.
I got you.
All right. Good afternoon, Chair, members of the board. This is for BOA 0044 2021 4401 Auburn Church Road. This request is for a special use permit pursuant to section 6.3.3.d and 10.2.9 of the Unified Development Ordinance for a telecommunication tower greater than 250 feet. The property is 107.82 acres and is split zoned heavy industrial conditional use and residential 4. Just with that, I'll hand it over to the applicant for his presentations and will be available for any questions.
All right. Board questions? Justin? All right, we have Toby, you the applicant attorney here?
I am.
All right.
Hey, good afternoon. This is Toby Coleman with Smith Anderson here on behalf of the applicant Duke Energy. Can you hear me?
I can.
Okay, excellent. We have a few folks with Duke Energy and our engineering team that are here today as well. Do you want to go ahead and get us all sworn in?
Yeah, and Catherine, can I do that as a group? I can't remember how we do that when we have multiple people. We have 5 or 6 here.
Well, typically,
We got to do his name and address, so let's just do one
we need
more.
everybody's name and address. Yeah.
Right.
So
Okay.
Sure.
All right, I'll
I
start
can do
from the top.
that. Toby Coleman, 150 Fayetteville Street, attorney with Smith Anderson here on behalf of the applicant Duke Energy.
Do you swear or affirm the testimony you provide will be the truth, the whole truth, nothing but the truth?
I do.
All right. Logan Nesseth, or Nesseth? Is Logan joining us? All right, Caleb Jurgensen.
Caleb Jurgensen, 9400 Ward Parkway, Kansas City, Missouri.
Okay, and do you swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. David Fulmer.
Hey, David Fulmer, 124 Watersong Lane, Irmo, South Carolina.
Okay. And do you swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Josh Goins.
John Goins.
Oh, John, sorry.
Yes, I'm at 326 Tryon Road, Raleigh, North Carolina.
Okay. Do you swear or affirm the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And lastly, I have Dale Brooks.
1120 East Franklin Boulevard, Gastonia, North Carolina. It's Dale Brooks.
Okay, Dale Brooks. Okay. Do you swear or affirm the testimony you provide will be the truth, the whole truth, nothing but the truth?
I do.
Okay.
Sure.
Back to you, Toby.
This is Logan Nessett.
right.
Can you hear me?
Okay, Logan's here. Okay, glad you can join us. Logan, name and address, and I'll go from there.
Logan Nessett, 9400 Ward Parkway, Kansas City, Missouri.
Swear or affirm that testimony you provide be the truth, the whole truth, and nothing but the truth?
I do.
Okay. Any more participants not signed up? And that's it. Okay, back to you, Toby.
All right. Thank you, Vice Chairman Coons. So this is, as was outlined, this is a special use permit request for a new 300-foot telecommunication tower at 4401 Auburn Church Road, which is a 60-acre property located in an industrial zoned area not far from the I-40 Jones Sausage Road interchange. If you go to the next slide. Here's the proposed tower. Just to give you a general sense of what this property is. So this property is the site of Duke Energy's Project Walter, which is a new control center for its electrical grid. There'll be about 200, there's gonna be a couple of buildings built on the site, or actually are in the process. That project went through site planning approval last year. ASR 31-2020 is the number. And all dedications of streets and easements associated with development on the property that were required by the city were done by plat earlier this year and recorded. As staff report notes, the property is zoned heavy industrial IH, and the proposed tower is permitted as a special use in the IH district. Just for your knowledge, I think it's shown a little bit in the report, but the property to the northwest and south is also zoned to IH. And the portion of the property where the tower will be located is designated for general industrial on the future use land use map, and the surrounding properties are designated for similar uses. So the use is compatible with adjacent uses, won't create any adverse impacts, and is adequately served by the existing road network. What I've got there up on that slide are the various specific use standards. It will be lighted in accordance with FAA requirements. Submitted as part of our applicant evidence is a determination of no hazard to air navigation issued by the FAA in November 2020. Basically provides that there will be lighting required pursuant to the FAA standards, which is what the code requires. You can see the plans up there will be designed to accommodate 5+ antennae. And we have done a review. There are no towers within 1,000 feet. Our engineering team has reviewed that. They're on the phone and can provide more details as needed. If you go to the next slide. So one of the issues we have set out in the code are setbacks. Because this is on industrial zone property, you're supposed to provide a minimum 150-foot setbacks. As you can see, the setbacks all exceed the required amounts. We've also provided, there is a residential property to the northeast, but that's almost 1,500 feet away. So there's significant setbacks on this property. If you go to the next slide for the antenna. Here is the tower, just a sort of a site plan. It will be enclosed by 8-foot tall fence, which is what's required by the UDO. If you go to the next slide, and here is the landscaping. The UDO requires landscaping both along the street and landscaping along the side of the fence facing the street, both of which will be provided. Generally shown here, which shows that the landscaping will be provided consistent with the UDO. Like I said, we have a team available for questions, but you know, what I wanted to do here was just briefly outline all the evidence showing that we meet all the special use permit requirements. If you have any questions, both myself and our team are available to answer anything you may have.
Thanks, Toby. I have no one else signed up for this for support or against on mine. So any questions for the applicant from the board? Anything from staff? I will, on that note, we'll close the evidentiary.
Sorry,
Okay, no.
I do not have anything signed.
Okay. All right, we'll close the evidentiary component of the hearing, and we'll move to board deliberations, or I'll entertain a motion.
I make a motion we approve.
I'll second. Although I will say I do find it odd that we'll pay attention to landscaping at the base of a 300-foot tower.
Yeah, city code.
Yeah, that's right. That's right. Maybe one day we'll put a vine on it or something. I don't know. We'll cover it with Confederate jasmine. All right, Ralph, we're better for you.
Thank you. Forgive me, I just want to make sure, Mr. Sutton, were you the person who seconded the motion?
Kathy.
No, Kathy got the motion. I seconded.
Kuntz was second, sorry.
Thank you, sir. All right, on the motion to approve. Ms. Rudisill?
Approve.
Thank you. Vice Chairman Kuntz?
Approve.
Thank you, Mr. Sutton.
Approve.
Thank you, Mr. Butler.
Approve.
Thank you, Mr. Kenny.
Approve.
Thank you. That makes 5. Thank you.
All right, somebody have a comment?
Could I ask a quick, I'm sorry, Chair Kuntz, could I ask a quick question? Mainly, this is for a matter that's coming up a little bit later, BOA 47-2021. Has that been continued? What is the status of that? I've got some people that I'm trying to make sure that if they don't need to be on the line, I can let them go.
Catherine, you want to talk about that?
Sure. The board's going through the agenda in the order that it appears, or the cases in the order of the agenda. They have not gotten to that case yet. If
Okay.
the
Sorry, my apologies.
No, it's okay. I mean, it's up to the chair if you wanted to go out of order to allow that one to, if it's going to be continued, to have that done, so that their participants don't have to stay on the line. But it's the chair's discretion.
Is that the one where we had opponents seeking to continue and the applicant had been non-committal for continue or not?
Yeah, that was where we had been, there was opponents who signed up in opposition, and the opponent's attorney told staff before the hearing they intended to seek a continuance. So that would have been addressed at the start of that hearing anyway. Mr. Coleman is the attorney for the applicant, and it sounds like I won't speak for Mr. Coleman, but the applicant might consent to that continuance so that if all parties are on board, you could go ahead and continue that if you wanted to go ahead and jump that one next.
Well, I'm all for being efficient and not wasting people's time. So, Mr. Coleman, are you saying that, that as the applicant attorney, that you were okay with seeking that continuance, like the opposition has seek?
Yeah, we do not oppose the continuance. I wanted to make sure that there was, frankly, somebody here, but I think, yeah, there was that request from a neighbor who sought a continuance, as I understand it. And so, you know, we are trying to talk with the neighbor, and to the extent that they're still making that motion, we are okay with that. To the extent they're not, I need to make sure that my people are on the line, frankly. So
let's do this.
We do have the opposition on the line, so if that's what he's seeking clarification of, we
okay,
both
yeah,
the neighbor
that's
and
all
their
I wanted to
attorney
make sure
present.
on. I didn't want to create a problem where, you know, nobody was making the motion to continue and then I wasn't ready to go forward because I thought they would. So long as we have that, we do consent to the continuance.
Okay, well, I want to be respectful of Michael Birch's, his crew's time, because they're next. But so if the applicant is okay with continuance, and I know the opposition is okay with continuance on BOA 47-2021, I'm in favor with granting that continuance right now. Can we confirm that the opposition is still okay with continuance, Catherine?
Yeah, let's do this. Let's go ahead and just procedurally go ahead and just call the case. It's you want to move that one ahead on the agenda.
Okay.
It's evidentiary hearing D under new business 717 Martin Luther King Jr. Boulevard, variance BOA 47-2021.
Yep.
And as you stated, there is somebody signed up in opposition who indicated the request for continuance. So that is Randy Herman is the attorney. So if you want to check with Mr. Herman to make sure that, or to see how they want to proceed,
Yeah.
are they requesting the continuance?
Mr. Herman, are you on the line?
Yes, I'm here.
Are you still in favor of, excuse me, you're the attorney for the opposition.
Yes.
Are you seeking to continue this case?
Yes.
Okay, and Mr. Coleman, on behalf of your applicant, are you okay with continuing this case to a later date?
Yep, no opposition to that.
And I have that date to be November 8, 2021, as of right now?
That works.
Okay. Mr. Coleman, does that work for you?
That is acceptable.
Okay. All right, well, we'll continue case BOA 0047-2021, 727 Martin Luther King Jr. Boulevard.
To November 8th, 2021.
Yep. Okay.
Great. Thank you.
All right, thank you, Mr. Coleman. You, Mr. Birch and his team a favor.
Will do.
All right, next case, BOA 00452021, address 710 West North Street and 401 North Portland Avenue, 405 North Portland Avenue and 708 West North Street. Let's go with Mr. Butcher. Are you doing the staff presentation on this?
Correct, yes.
Proceed, thank you.
All right, thank you. This is for BOA 0045-2021, 710 West North Street, 401 North Boylan Street Avenue, 405 North Boylan Street Avenue, and 708 West North Street. Glenwood South Partners LLC, property owner, requests one, a 5-foot variance from the maximum building height requirement of 40 feet as set forth in section 5.4.3.f.10.c of the Unified Development Ordinance for 2 5-unit apartment buildings fronting West North Street and 1 6-unit apartment building internal to the site. A 4-foot variance from the front wall offset length requirement of 10 feet as set forth in UDO section 3.4.4.f.2, applicable to the 2 apartment buildings fronting West North Street, and a variance from UDO section 3.4.4.e.1 to not have a primary street facing entrance along North Boylan Street for the construction of apartment buildings located at the following addresses: 710 West North Street, 401 North Boylan Avenue, 405 North Boylan Avenue, and 708 West North Street. The site you can see here, it is 0.77 acres and zoned office mixed use 3, detached frontage. and it is also located in the North Boylan Neighborhood Conservation Overlay District. Here you can see a basic plan view layout of the site. Buildings 1 and 2 are at the bottom facing West North Street, and the internal building is located in the northwestern portion of the site. And here you can see just some examples of the architectural elevation overlays for buildings 1 and 2. It kind of just gives you an idea of the topography and grade change present on the site. Staff would also like to inform the board that there is a current text change being drafted that, if approved, basically it will improve how the UDO addresses sites with topography for commercial and mixed-use projects. And it's just kind of given, it's understood that sloping terrain kind of presents unique challenges, and that this text change would add an option to the UDO for the measurements of height along slope sites, essentially allowing applicants to break buildings up into separate modules with height determined for each module, kind of just encouraging buildings to follow topography. So with that, I think I'll hand it over to the applicant, and I'll be available for any questions.
Thanks, Justin. I have it that Michael Birch and Jennifer Ashton will be presenting the case. Is that correct?
Jennifer Ashton will be, yes.
Okay. All right, and we have 3 applicants that will be presenting as well. Let's go ahead and get the 4 of you sworn in. Jennifer Ashton?
Yes, I'm here.
And I got Roland Gammon, Ken Thompson, and Linda Davis as well.
Linda Lavis with an
Linda
M.
Davis, sorry.
That's okay.
All right. So is Roland and Ken not joining us, just Linda?
No, I'm present, Ken Thompson.
Okay, Tim. Roland, is he going to join us as well or not?
I believe he was having an issue with audio earlier. He will not be presenting any testimony. He would just be available to answer questions, but I'm not sure if he's still on or not.
Okay, well, if he joins us, we'll swear him in. Let's go with Ken Thompson. State your name and address, relationship to the case.
Yes, Ken Thompson, 510 South Wilmington Street, Raleigh, North Carolina, 27601. And I am the land planner, landscape architect for this project.
Okay, do you swear or affirm the testimony you'll provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Linda?
My name is Linda Lavis. I'm with J. Davis Architects at 510 South Wilmington Street in Raleigh, 27601. And I'm the architect for the project.
Do you swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And that's it, right? Yep. Okay. All right, Jennifer.
Thank you, Mr. Chair. My name is Jennifer Ashton. I'm a land use attorney with the law firm of Longleaf Law Partners. Our address is 4509 Creedmoor Road, Suite 302. I'm here today on behalf of the property owner. We are asking for 3 variances at the site on your, or the multiple properties on your screen. I'm joined today by Ken Thompson and Linda Lavis, both architects with J. Davis. They will be our expert witnesses for this hearing. Before I turn it over to them to offer testimony, I did want to do two housekeeping items. One, if I could have our application and our presentation formally admitted into the record.
So moved.
Thank you. And next, I will go ahead and give you a brief summary of the variance requests, and then I'll turn it over to Ken and Linda. Ray, could we go to the next slide, please? Thank you. As Justin mentioned, we are asking for 3 variances. The first variance is a building height variance. We're asking for a 5 feet variance from the maximum building height, where the UDO requires that we have a 40-foot maximum height. Height is measured currently by the average post-development grade along each primary street. As Justin mentioned, this does provide some issues when you have a site that has significant slope challenges like we do, and Ken will be addressing those more in just a minute. Our second variance request is from the front wall offset length requirement. Under the UDO, offsets are required to be 10 feet by 10 feet. We are going to be proposing offsets of 10 feet by 6 feet. That actually only applies to 2 units within the development, so it will not be applying to all the units And those units are located one in building 1 and one in building number 2. And then finally, we are asking for a variance to not have a primary street facing entrance along North Boylan Avenue. This variance request only applies to unit number 10 in building number 2. The UDO does require that we have a primary street facing entrance along both North Boylan Avenue and along North Street. We are asking for only one primary entrance. And with that being said, I'll turn it over to Ken Thompson to run through the specifics of our request.
Okay.
Thank you.
We advance in the next slide, please. Slide 4. Thank you. Just to give you a quick overview of the site, it's 0.77 acres. It's at the intersection of North Streets, West North Street and North Boylan Street. So I'll probably not refer to the north and west often, just to keep from confusion. The site along North Street slopes from west to east about 7%, 7.7%. And then the site slopes from North Street to the north property line to that mixed use building at about 4.7%. And along Boylan Avenue, I'm sure many of you are familiar with the site, the grade there is about 5 foot above the street level. So you can see we have some topographic challenges ahead of us. We have, if we could advance to the next slide, please. There we go. Thank you. We propose 2 internal alleyways. The Acrobat Court, the one that running east-west, that is sloped similar to North Street, obviously, so that we can accommodate the units and not have the sloping up, from front to back of the unit. And then the North-South Street is sloping about, again, 4.7% towards that north property line. So we're trying to stay, stay within the existing grades at the adjacent property lines. The one little single family house property to north of us is actually, apparently there's a retaining wall between us and them, and us regrading the site would remove that retaining wall, and we would be at the same level as they are. We can advance to actually slide 7. That's 3 slides ahead. Thank you. This is buildings 1 and 2. They both front North Street. As you can see, the topography there is shown in the steps of the buildings. Each building has 3 steps. Across the face of building 1, which is on the left-hand side, that accommodates about 5 foot of grade. And then on the right-hand side on building number 2, that's about 4 foot of grade across there. The buildings are only they are only 38 feet tall when not taking grade into account, which is within the allowed 40 feet. This is a designation of a 3-story building district with a 50-foot height limit, but the overlay district limits it to 40 feet. So you can see is when we go to measure the average grade, that increases the building height significantly by several feet. That forces us over that allowed 40 foot. I think both on these buildings, it's approximately 8.5 inches on these 2 elevations. If we can advance back to slide number 5, should be back 2 slides. Thank you. Now we'll look at the Boylan Street relationship to the buildings. I neglected to indicate at the beginning. We have 2 primary streets here because both of the streets are mixed-use streets. So that's why we have, our height request you'll see is for 2 different streets. So we had to measure building height from both streets, which is, is a double whammy. So building 1 and 2, now we're looking from Boylan Street, and as in the previous slide, they were stepping down. So the elevation that you see here is the one on building number 1, parallel to Boylan Street. And you can see in the elevation there that the building steps up. So when we measure the Average grade plane, we have to go from, the average grade across the building face to the highest point of the building, which in this scenario is several feet uphill. The site also slopes to accommodate the existing slope towards the north. That we step down about 2 feet from front to back to the garage. And then that adds even more height onto those two buildings. And this is the same scenario for building number 2, which is the next slide. You can see the same scenario there. If we could advance to slide number 9, I think that's which one it is. One more, it should be another long building elevation. Okay, this is building number 3, which is internal to the site. Again, since we have 2 primary streets, this is the face that's parallel to Boylan. We did not have a problem with building height on the side of the building facing north. But again, to maintain the existing slope of the site, we're sloping from left to right at about 4.7%. And the building drops about 3 feet to follow the slope across that frontage. When we put the average grade in there, that increases the height of the building by about 1.5 feet and causes the building to become non-compliant. That's the end of the presentation for the building height request.
Thank you, Ken. If we could go on to Linda Levis, she is going to talk about the offsets.
Okay, so this project is located in a DE frontage typology. And the DE frontage, the intent of the DE frontage is to maintain the residential character of the street. It calls for a maximum 40-foot wide expanse of blank wall to be broken up with 10-foot by 10-foot, 10-foot wide by 10-foot deep setbacks in order to articulate the building along the street face. This 10-foot by 10-foot wide setback makes a lot of sense for a large single-use commercial building or even a large single-family home. But for a 16-foot wide townhome, this 10-foot by 10-foot wide setback is out of scale with the 16-foot width of each individual unit. We understand that the point of this requirement is to have facade articulation along the street, to not have one large blank flat wall. And what we've done, or what we're showing, is articulation that is more in scale with a townhouse topology. So what we've done is we've taken the middle unit on both of these buildings that face North Street, and we've pushed the entirety of the middle unit back a full 5 feet from the facades of the other units on either side of it. So there's 2 units that are aligned, 1 unit that recesses back fully 5 feet, and then other 2 units that come up further again to the main setback line. We've done that on both buildings to break it up. Additionally, where the entry lies, we've pushed that back the full 10 feet from the front setback plane, and that setback is 6 feet wide. So we are requesting, instead of the full 10-foot by 10-foot wide recess that we feel is inappropriate for a townhome of this scale, that we have a 10-foot wide by 6-foot wide setback. And also, if you go to the elevation sheet, which is page 7, you can see that, next one, sorry, page 7. There you go. You can see that the unit in the middle, it's hard to tell in this 2D, but it's pushed back, that main facade 5 feet, and then the roof form changes. So you get the sense that the building is breaking up, that it's not one large continuous building, but that it's comprised of 5 different units. And then the center unit is going to provide a deeper shadow line.
Okay, thank you. And Linda, I just wanted to make sure I didn't cut you off there.
No, you're good. Thank you.
Okay. And we'll turn lastly to Ken Thompson again to discuss the primary street-facing entrance.
As I noted earlier, the site has two primary streets, two mixed-use streets. And we have a residential project. And DE requires a street-facing entry on each building. And in this scenario, we would be required to have a townhome with a entry on two streets. We feel that if this was an apartment building or an office building of that nature, it could be accommodated more easily. But this being a townhome, having that second door on Boylan, can create some additional concerns with the occupants for safety. There's two sets of doors to come to, maybe some confusion of what the address is possibly. So we request that we be required to only provide one street-facing door on North Street.
Okay, thank you for that, Ken and Linda. This is Jennifer Ashton again. I'll just give a quick summary of the testimony that you've heard. There are some very unique topography challenges with this site, some pretty steep grade changes. We believe that we've demonstrated a hardship with respect to how the city actually calculates building height. And we think that we have met the hardship standard for the building height variance. With respect to the offsets, again, this is an unusual configuration for the assemblage overall, with the grade changes as well. And then also on this slide that you see in front of you, there is some additional right-of-way that we are being required to dedicate to the city for West North Street. All those things, they really are squeezing the site. And as Linda explained, the offsets that we are proposing fit within the site building area, but also provide a good offset and articulation to meet the intent of the code. And then finally, with respect to that second primary street facing entrance along North Boylan, as Ken described, putting a door into a garage off of North Boylan, that could pose some safety concerns in the evening or nighttime hours. Nobody will be watching that door at those hours. So we are requesting that we only have to provide a primary street facing entrance along North Street. And again, just to emphasize, this primary street facing entrance variance is only for unit number 10 in building number 2. And with that being said, we thank you for your time and we'll be happy to answer any questions.
Thank you for the presentation. I don't see any other additional participants to support or oppose. Anything further from the applicant? Are we good?
Not at this time unless you have questions.
Staff, anything to add?
No, nothing to add.
How about the board? Any questions or anything for the applicant? Hearing none, we will close the evidentiary portion of this hearing and open up for board deliberations. I'll start. I don't have any significant problem with the height of the door, anything proposed there, or the offsets. I think it's appropriate. In my review, I'm interested in hearing what anybody else has to say on the board.
I would agree, with the topography, it's a given. So I would agree with you, Chairman Coombs.
Hearing that and hearing no other input, I'll make a motion to approve.
Second.
Ralph?
Thank you. On the motion to approve, Vice Chairman Coons,
Approve.
Mr. Butler,
Approve.
thank you. Mr. Sutton,
Approve.
Ms. Rudisil,
Approve.
Mr. Kenny,
Approve.
thank you. That makes 5.
Thank you.
Thank you very much.
All right, we're going to, anybody want to take a quick break? I know we've been kind of at it for a couple hours. Let's do that. Let's do a quick 5-minute break. To get everybody caught up on what they need to do, and we'll reconvene at 3 o'clock sharp. got, BOA case 00462021, that's 1921 French Drive, Terry Wayne Phillips, property owner, special use permit. And I have, Eric Hodge, with a staff presentation.
That's correct. BOA 0046-2021 is a request for a special use permit pursuant to section 6.7.3.e and 10.2.9 of the Unified Development Ordinance in order to add a 2-car bay to an existing 4-car garage via the conversion of an existing workshop space through the addition of an additional double car garage door on a 0.49 acre property zone residential 4 located at 1921 French Drive. So this is a recently constructed home, so it's not shown in the aerial. This is the approved site plan. So the garage is at the rear of the property facing the eastern property or the property to the right. So as you see on the right side of this property, the driveway comes in, goes beside the eastern side of the home, and then turns, and those existing garages shown here on the second image from the top are actually entered and facing the side property, the property to the east. So at the far left side of that structure, it was approved and permitted as a workshop space and did not have a garage door. However, they are proposing to remove the portion of the wall there and replace it with an additional 2-car garage door. So that would be 3 2-car garage doors for a total of 6 parking bays. And the code requires a special use permit for garages of 5 or more spaces, as you may recall from previous board cases related to oversized garages. The code has standard special use permit findings. We don't have anything specific to garages for 5 or more vehicles. We just have a special use permit requirement for when someone proposes those. So the standard 8 special use permit findings are in play. Those are within your staff report. And again, are just sort of the general special use permit provisions that apply to all special use permits the board would consider. Happy to go through those or answer any specific questions you may have at this time. Without hearing any, that would conclude my presentation.
Thanks, Eric. Board, any questions? All right, hearing none, let's go to Isabel Maddox. Are you with us?
Good afternoon, Mr. Chair and members of the board. I'm Isabel Maddox, P.O. Box 946, Raleigh 27602. Here today on behalf of Terry Phillips, the owner of the home at 1921 French Drive. First, I'd like to move that the application materials and exhibits presented be accepted into the record.
So moved, thank you.
And so although this home is not yet fully complete, Mr. Phillips has already had this property, this building approved and mostly constructed. And I'm not sure exactly when he's moving in, but it's pretty close. So if you'll go to the next slide, please. On that, we have a site plan, and if you'll look at that site plan, you'll see there's the house that sort of the front part of the house consumes the area closest to the street. And as you go back, you'll see a skinnier portion which is the garage. That was built as 2 garage bays plus a workshop bay. And he's simply wanting to convert the workshop area to a 2 more car garage. The size of the building, this is important, the size and the massing of the building and the impervious coverage will all stay the same, whether this special use permit is granted or not. That structure is there and it will remain the same. But for a garage for more than 5 cars or 5 or more cars requires a special use permit. And as Eric alluded to, there are several standards in the UDO that are required to be satisfied, which will make my client entitled to a special use permit if those are satisfied. So I want to go through those. If you'll go to the next slide, please. We're going to go through those. We'll actually go to the next one after this. Okay. The first one is the proposed use complies with all applicable provisions of this UDO. And that is in fact the case. A garage is certainly permitted to attach to a single family dwelling. This structure has been approved by city staff. The only thing necessary here is that we get a special use permit to allow this to be a 6-car garage. The second standard is the proposed use is allowed as a special use in the respective zoning district. UDO section 6.7.2 permits garages for more than 5, I think it's 5 or more cars with a special use permit. The next standard is the proposed use complies with any specific use standards listed in Chapter 6 for this particular use. There are no specific use standards here. Okay, if you go to the next slide, we'll continue on with these standards. And this is the kind of the crux of the matter here today. The proposed use is compatible with adjacent uses in terms of location, scale, site design, hours of operation, and operating characteristics. And I'll break this down into several different pieces. First, use, hours of operation, and operating characteristics. And of course, this is not a business, it's just a home. So the proposed use is for the homeowner's personal collectible vehicles. He has some nice vehicles he collects. He has several at any one time. He really wants a nice place to store those. The hours of use would be those of a typical homeowner using a garage for his personal use. He can only drive 1 car at a time, so it's not like he's going to be driving 6 cars out at the same time. He's just going to be driving 1 at a time out. So we believe that the use, hours, and operating characteristics are similar and compatible with others in the neighborhood. Location, scale, and site design. Now, as I said, the only change to this existing approved and constructed building is the addition of garage doors to one of the bays, which was originally planned as a workshop. The scale of the garage is actually lower in height than is permitted in the neighborhood. Heights of 40 feet are permitted in adjacent neighborhoods, but this garage is less than 30 feet tall. It's very similar to other buildings in the neighborhood. And the site has been designed to place the garage out of view from the street, so you can't even see it as you drive down French Drive. And that's either the existing garage, the 4-car, or the new garage doors. And as to the neighbors, the garage is in a location where the garage doors were screened from view on all sides. First, we'll go to the left side. The left side is probably the most impacted side. The garage itself is set back about 50 feet from the side lot line on the left. There's an 8-foot tall fence, approximately 8 foot tall, solid wood and metal fence that screens the garage from the view of the most affected neighbor. I'll show you a picture of that in just a second. And importantly, this neighbor, these neighbors, I should say, Mr. and Mrs. Downing, have submitted a notarized letter supporting this request. And I'll show you that as well as we go forward. On the right side, now that party can't see the garage doors at all. And the massing of the building that they see is going to be the same either way. In addition, those folks, the EPs, have also submitted a notarized letter of support. And finally, to the rear, there's about 60 feet between the edge of this garage and the rear lot line. There's also an 8-foot drop in elevation going back, and there's significant evergreen trees in that area, and we can see that on an aerial photo that I'll show you in just a second as well. Next, I want to go to, okay, you've already got you thinking ahead of me, Eric. Thank you. Okay, adverse impacts resulting from the proposed use in the affected area will be effectively mitigated or offset, or if not, the special use can be denied. So what kind of adverse impact could we have here? It could be aesthetic, could be visual, or there could possibly be stormwater impacts when you add a garage. But here, the aesthetic or visual impacts are mitigated by screening from the street and from the neighbors and having a lower height than the maximum allowed. And impervious does not increase. We're going to have the exact same amount of impervious coverage whether or not this special use permit is granted. So I don't think there are any adverse impacts that aren't effectively mitigated here. Next is access with respect to pedestrian, bicycle, automotive, safety, traffic flow, and emergency services is adequate. Those things will be exactly the same. Access will be coming from French Drive, a residential street, onto the property via a paved driveway. And it won't vary whether the special use permit is granted or not. Signage is suitable. We propose no signage here. Any appropriate dedications of streets and utilities will be made. Again, there's no utility or street dedications required here. So continuing on, I want to show you a couple of slides that referring to things I mentioned earlier. That's the fence that runs along the left side, the easternmost property line. That's actually on the neighbor's property, but it's, significant solid fence that pretty much screens their view. Next slide that's from the rear. You can see the drop in elevation, and you can see the 3 different openings to the garage there. And then next slide, please. Again, that's just a different view from the side. And you can see there's a fair amount of space between that facade of the garage and the next door neighbor. Then next slide, please. These are the 2 neighbor support letters, and they're probably difficult to read. I had intended those to be on separate sheets, but they got put on the same one. The first is from Walter and Mitzi Downing, and the second is from Matthew and Dana Epps. And I'll just quote part of their letter. We acknowledge that the structure will be the same size regardless of whether the 2-car bay is added, and believe that the new home will improve the overall character and appearance of the neighborhood. We support this special use permit in accordance with the application filed. So to summarize, if you'll go to the next slide, please. All the special use permit standards have been satisfied. The massing of the building is exactly the same. No additional impervious will be caused by adding these 2 new garage bays. There'll be little or no visibility from the street or the adjacent property owners. From the street, not at all visible. From the left side, there's a tall fence blocking the view. On the right side, not at all visible. And from the rear, there's a blank there, but it's 60 feet away from a wooded buffer. And then I think we have letters of support from the 2 next door neighbors, one of whom is the Downings, which are the most impacted on the immediately to the left or the east. So I think we feel like we've satisfied all those requirements and would request your approval, and certainly am available for any questions. And I have Mr. Phillips. I kind of had a crazy week last week, and I did not tee him up to sign up to speak in time. He is tied into me via cell phone, and if you have any questions for either one of us, we can try to answer those.
Thank you, Mrs. Maddox. If we need him, we will patch him in. There are no opponents signed up today to speak or offer anything. So having said that, anything else you need to add, or are you good?
I'm good, thank you.
Okay. Staff, anything more from you, Eric?
No, sir. Thank you.
Okay. Board, any questions of Mrs. Maddox?
No.
And on that note, we will close the evidentiary portion of the hearing and open up for board deliberations.
Pretty straightforward.
I agree. Entertain a motion?
So move.
Or a second?
What'd you move to do? I'm assuming for
I'm
approve.
sorry, to approve.
Yeah, I asked if there was a motion. Marvin offered a motion for approval, seconded, I think, by Mrs. Ruderson. Is that correct?
That's correct.
Okay. All right, Ralph?
If I may say, a very efficient motion.
Yep.
Motion to approve. Mr. Butler?
Approve.
Thank you, Ms. Rudisil.
Approve.
Thank you, Vice Chairman Coons.
Approve.
Thank you, Mr. Sutton.
Approve.
Thank you. I think that's it. 5 votes. Thank you, sir.
Thank you. And we have final, seeing it has, where we go? Yeah, 727 Martin Luther King was continued per our earlier conversation. We have one more to go. That would be BOA 00482021, 120 Kinley Street, Capital City Urban Development. And Justin, I believe you're doing the staff presentation here as well.
Yes, that is correct.
All right.
I think I just need the presenter privileges.
Michael Birch, are you here to do the applicant's case?
Yes, sir, I am.
Okay. All right, we'll start with Justin, then we'll move to Michael. Thank you.
All right, thank you. So this is for BOA 00482021, 120 Kinley Street. Capital City Urban Development LLC requests a variance from the requirement to provide a minimum tree conservation area of 10% of the net site area per UDO section 9.1 in association with the subdivision of land and construction of apartments located at 120 Kinley Street. The property is 6.03 acres and is zoned downtown mixed use, DX20. And the applicant has provided the following condition, and I will read it now. In lieu of compliance with the tree conservation ordinance, the property owner shall comply with this condition. The property owner shall pay to the city of Raleigh an amount of $26,510, which shall be held and used by the city in accordance with UDO section 9.1.5.E.3, requiring funds to be used on tree planting or acquisition of land with preserved trees. However, this amount may, at the election of the property owner, be reduced at a rate of $100 per caliper inch for every new tree planted on the property that is at least 2 caliper inches in size. Trees counting toward compliance with this condition may be planted on the property within adjacent right-of-way that may hereafter become part of the property within the adjacent public right-of-way, subject to the approval of the applicable governmental entity, or within the adjacent railroad corridor, subject to the approval of the applicable entity. Trees required to be planted on the property or within the right-of-way by the UDO may be counted towards compliance with this condition so long as the trees are at least 2 inches in size. This condition shall be satisfied no later than the issuance of a certificate of occupancy or new building on Lot 2 or Lot 3, whichever shall first occur, or at an earlier time at the election of the property owner. So with that, that concludes my presentation, and I'm open for questions.
Board questions for Justin. I've got a couple, but that may be better suited for Michael. I think we want to dive into the definition of caliper. I think some of that stuff, I may not be speaking for the entire board, but I can assure you that there's probably some drilling down on this condition. Justin, do you want to try to answer these, or kind of wait for Michael to present that, and then we can kind of get into that a little more? Probably the latter.
I'll wait for Michael to present his.
Okay. All right. Any other questions for Justin or staff? All right, Michael, floor is yours.
Applicant. Sorry, can you hear me now?
I got you now. Yeah, thank you.
Yeah, Michael Birch, Lone Leaf Law Partners, here on behalf of the applicant. We do have a presentation that's been pulled up. If we could go to the next slide. So, Mr. Koontz, I heard your question, and I will, if it's okay with you, I will kind of explain that condition towards the end of the presentation, if that.
Yeah, that's fine. You can take it all. Yeah, I'm sure there'll be more questions. Thank you.
Yeah, thank you. So again, as was mentioned, this request is for complete relief from the tree conservation area requirement, which would allow for the removal of those 12 trees that would otherwise be designated as secondary, not primary, but secondary tree conservation area. We're not asking for relief from any other landscaping requirements, just related to the tree conservation of those 12 trees, which I'll show on the plan. And it would be, again, subject to that condition that was just read. So the owners of this property in one form or another have owned the property for over 5 years and have been trying to develop it ever since that time, a portion of which would be planned to be used for the Exploris Middle School. These property owners have received preliminary site plan approval for a mixed-use building apartment development, kind of where the parking lot is on the site. And Exploris is planned to go kind of in that green open area close to the railroad right-of-way. But tree conservation has been an issue from the beginning on this site over the many iterations of them trying to develop this property. And after 5 years or so, we are kind of at the point of last resort. And so that's why we're here with this variance request. So as you can see from the map, the property is located at the southern end of downtown. MLK is located to the south of the property. The McDowell, Dawson McDowell, is located to the west. We have the rail corridor to our immediate east, with the convention center to the north, Memorial Auditorium there to the east. If we could go to the next slide. See, again, the property's got some existing improvements on there, that existing building and parking lot improvements. Also, you'll see that Kinley Street, that's the street that comes off of Salisbury, kind of west, heads into the site. That, as I'll show on future slides, is planned to now go through the site and connect to Martin Luther King Jr. Boulevard as part of a kind of complete redesign of the interchange of Dawson, McDowell, and MLK. As a result of that, the area that's located between the property and MLK, which includes that current ramp, will likely be abandoned by NCDOT and conveyed to a private owner, as well as the right-of-way between the property and McDowell Street, to really kind of, as part of the city's BRT project and NCDOT's interchange project, in order to kind of bring development closer to the street, increase kind of transit ridership with proximity and better, pedestrian bike access in this area. If we go to the next slide. So this is the tree conservation plan that's associated with the subdivision plan for the site. You'll see that kind of gray kind of line that goes through the property. That is the right-of-way for Kinley Street. And then you'll see kind of the darkened circles along the left side. That's along McDowell Street. That represents the 12 trees that have been designated, or that would be required to be designated and saved as secondary tree conservation. The other trees that are on the site and shown on this plan are impacted either because of the existing improvements or existing or proposed easements required as a part of development of the property, which I'll touch on in a moment. We go to the next slide. So this is a zoning map. Property is zoned DX20. It's the downtown district that allows up to 20 stories. The DX district requires mixed-use buildings, requires wide urban streetscapes, and anticipates buildings, being placed at the street edge. This is really meant for the most urban parts of the city. What's unique about this property is that it is not zoned with a frontage district. It's not zoned with an urban frontage like urban limited, urban general, or shop front. It was not applied to the property by the city during the remapping process in 2015, 2016. I want to note that if it was zoned with a frontage, no tree conservation area would be required. Frontages impose build-to requirements, and there's an express provision in the code that says where there's a build-to requirement that trumps tree conservation, the build-to requirements prevail, and no TCA is required there. I also want to note what's unique about this property is related to other downtown DX properties is that this is really one of the few that is greater than 2 acres in size. And it's the only privately held property that I could find that is zoned DX and greater than 2 acres in size that does not have a frontage. The 2 acres is important because properties greater than 2 acres in size are the only ones that are required to provide tree conservation. You might imagine most of the properties in the DX and the downtown area are less than 2 acres in size and are therefore not required to comply at all with tree conservation. We go to the next slide. Again, this is just from a policy standpoint, the future land use map. Again, just highlighting this property is within the downtown district, designated central business district. We go to the next slide. It's the urban form map. Property is located within the downtown center, within a transit station area, with bus rapid transit planned along Western and Wilmington in very close proximity to this site. Those are the kind of purple circles that you see. That's a 1/4 mile radius from a planned BRT, bus rapid transit station. And the urban form map, really the role of this policy guidance is to guide how buildings should relate to the street. So if we go to the next slide, all of this policy guidance suggests that this property should have an urban frontage, which would mean no tree conservation requirement with buildings up to the street. And so all of these policies support no tree conservation in this location. We go to the next slide. I mentioned the Dawson McDowell interchange kind of realignment. So in this slide, our subject property is kind of in the purple on the right-hand side. It's got a dashed line going through it. That's the Kinley Street extension that shows it lining up with now an on-off ramp across Western onto McDowell. And if we go to the next slide, this kind of shows part of the future condition there. And if you look able to kind of see in the little black box there, it talks about, a main purpose of this interchange realignment. One is kind of that area along Western and McDowell is to go into private hands in order to expand the development potential along Western Boulevard, to improve the public realm, and to be better connected to BRT. And so the DOT's plans for this area calls for development adjacent to the streets, consistent with our variance request. We can go to the next slide. So this is just from the Raleigh Street Plan, just again highlighting that required extension of Kinley Street through the site. And it's also a good opportunity to just again say that kind of all that right of way that you see north of MLK and to the east of Dawson as a part of DOT's project, is planned to be abandoned and conveyed to a private party. So in that instance, the trees that we're talking about, which are along the west side of the site, would not actually be, along the right of way any longer, and really wouldn't, again, be serving the purpose of tree conservation. We go to the next slide. Again, just this highlights more just in that southeast corner. Again, there's existing public infrastructure and easements that really eliminate those trees from being counted towards tree conservation. We go to the next slide. The grade in this area along the western ramp, both kind of in the southeast corner and along western, there's about 16 feet of fall from our property in the right of way, over about 45 feet, works out to about 35% grade. If you go along McDowell to the next slide, we've got about 14 feet of fall over about 58 feet. So that's about 24% grade there. And so as a part of the subdivision, the dedication of right of way, we have to construct Kinley Street through the property. We're also providing a bike ped easement and multi-use path along the rail corridor between Western and Kinley Street. That requires a lot of grading activity, which again, kind of takes away the ability to save any of those trees in those areas. We go to the next slide. There are existing easements on the property. The area that is in green is that existing sewer line. Then the area in orange, highlighted in orange, is a 20-foot wide and 40-foot wide utility easement from Book of Maps 1976, page 410. Kind of inclusive within some of that orange area, there's also a permanent slope and permanent subsurface easement on Book of Maps 1993, page 1567. I do want to note that kind of the easement, particularly along McDowell, where it's a 20-foot wide utility easement, would actually impact and disqualify at least 3 or 4 of the trees that have currently been designated as TCA, but we kept those trees in for purposes of, the condition in particular, so that there would be a higher, new tree requirement or a higher replacement fee requirement. So we didn't want to reduce that. We kept it at the 10%, just again, trying to meet the spirit, purpose, and intent of the ordinance. If we could go to the next slide. Again, this is just the Alta. If there are any questions, we can go to the next slide. There is that, again, Kinley Street extension. This shows the 4 lots. Just thought it would be helpful to understand the current subdivision in this kind of southeast quadrant. That is where there's an approved site plan for the mixed-use building apartments. That's also where that bike ped easement and multi-use path is, connecting Western to Kinley Street. The kind of lot north of Kinley Street along the railroad corridor, that is where Explorers is planned to be. So those are the 2 lots referenced in the condition, again, which I'll explain further, but just wanted to identify that. If we could go, really don't need to go to the next slide. If we can just go back just to an aerial, just in case there are any questions. So wanted to kind of run through all of those to show that there are, existing improvements on the site that impact trees, existing easements that impact trees, that take them out of qualification, which is why we designated the 12 trees that have been designated and the ones that we are asking to be able to remove. From an unnecessary hardship standpoint, and I'll just refer to our responses in our application, but without this variance, there'd be a undue burden and limitation on the developable area of the property, and inability to redevelop the property in accordance with the city's goals and policies. and would potentially result in locating, these trees that would be saved where they would actually no longer qualify once the DOT project is complete and that right-of-way is conveyed to a private party. The conditions that give rise to this hardship are peculiar to the property. As I mentioned, it's really the only kind of privately owned parcel greater than 2 acres in size, zone DX, without an urban frontage. It's one of the few, if only, downtown sites that would have to comply with tree conservation. There's the, again, impact to the property through the requirement to dedicate and construct the Kinley Street extension, topography at the edges of the site where a lot of the trees are, the plan changes at the interchange and the release of the right-of-way by NCDOT, and again, the existing utility and slope easements that eliminate other trees from possibly being tree conservation. These are not from the actions of the applicant. Again, existing topo, existing easements, Kinley Street's on the city's plan. The interchange realignment plan is driven by NCDOT. And then the city's remapping did not apply a frontage here. We think this request is consistent with the spirit, purpose, and intent of the ordinance because it would permit development consistent with the city's policies, which envision an urban streetscape with buildings along the street that will improve pedestrian and bike access around the site, through the site, and access to transit. City's policies do not call for a heavily buffered streetscape in this location. It's consistent with the spirit because, again, it'll likely result in protecting trees interior to the site, which is not what tree conservation ordinance is intended to do. And lastly, the condition requiring planting new trees or a replacement fee is consistent with the ordinance. And so I'll kind of touch on our condition and kind of the reason why it's crafted the way it is. So,
and maybe there's a lot going on with the site plan. Thanks, Michael.
Yep.
And I want to make sure the board's clear of kind of what's being presented before we jump into the condition you're suggesting, because it is a complex site. There's topo, there's landscape, there's the urban frontage thing, and there's the Kinley Street thing. Can we talk a little about timing? So is the Kinley Street extension, is that going to be done when your applicant does the development, or is that a later stage thing, or is that just a condition that has to be considered?
No, that extension is the right of way for that is being dedicated as part of the subdivision plan.
Okay.
And the street will be constructed as part of that as well.
Okay, so that will be constructed up until.
Let me just clarify that will be kind of to the edge of the property as you see it today.
Yeah.
Again, we anticipate acquiring the adjacent right of way from NCDOT. As part of that, we are obligated to do a number of improvements to essentially effectuate their interchange realignment plans. That includes connecting Kinley Street all the way to Western. So there's an at-grade connection of Kinley Street at Western Boulevard.
All right, and then so you've got lot 3, lot 4, and lot 1 and 2. So when that, like, what is being, and maybe I just can't read these plans like I think I can. Like, what is being put where? Like, where is it the existing facility, or like, talk to me about like what's being built. Like, what's
so the ultimate plan for this entire site is for these existing improvements that you see here to be scraped, and there to be essentially at least 4 new lots with new development on it. I think lot 1, which is pretty much in the area of the parking lot that you see, that has already received, preliminary site plan approval for a mixed-use building with apartments above.
Mm-hmm.
That's lot 1.
Mm-hmm.
Lot 4, which is kind of in that a portion of that kind of greenfield area.
Yeah. Yeah.
That is, required to be conveyed to Explorus by the end of the year.
Mhm.
And so that's why, as a part of the condition, we didn't want to tie anything to that because we've got to record the subdivision plan and convey that lot by the end of the year.
Now, when you convey that lot, does that mean there'll be improvements made, like a building there, or is that just a lot as green space for them, or what is that? Can you talk
So,
about that?
yep. So under the agreement with Explorus, we are conveying them that lot, and then they are moving forward with, plans for their school.
Okay, got it. All right, so we got building on 1, building on 2, and
There are
building on
future
lot 1,
buildings
building on 4, probably lot 2 is probably undeveloped.
Well, again, lot 2 will likely be recombined with the
One.
joint right of way.
Yeah, right. Yeah.
Since the DOT releases that right of way.
And what about lot 3?
Same. But there are, there are plans for, again, larger mixed use buildings that are on those properties that will have to come through the development plan process, but
Right, okay.
yeah.
All right, so when you talk about no urban frontage being designated, I mean, that really is, in a sense, hamstrung the applicant, correct?
Correct. That's right. If we had an urban frontage, there would be no tree conservation required at all. And they would have, some of this would probably been built now. They would have moved forward back in 16 and 17 when they bought it.
So in your professional opinion, why do you think no frontage was put on that? Was it because of the complexity of the site and the railroad and the access from MLK to McDowell? I mean, what?
So the city, when they were going through the remapping process, and again, this is just
your opinion,
my opinion, having been involved in the remapping,
yeah.
But during the remapping process, the city evaluated kind of existing conditions and existing development when they were applying a frontage. And in some cases just didn't apply frontage at all. It's important to note that they didn't apply parkway frontage here, which would have required the retention of the trees along the street. That would have been kind of a clear policy decision if they would have designated it parkway. They didn't do that. I think they didn't apply the urban frontage because at the time, there wasn't this thought of this interchange realignment where McDowell and Martin Luther King are becoming more urban streets, where there would be even the possibility of buildings addressing those streets. The site at the time was really just served by a cul-de-sac and was otherwise bound by railroad corridor and very wide NCDOT right-of-way.
And the easements on there, yeah, okay.
Yeah, so since that time, right, there's been this introduction of the interchange redesign, and the city has also taken a lot of steps towards planning and funding bus rapid transit in this area. And so those two big policy shifts, are now kind of calling for development in this area to be brought up to the streets, and DOT's project will allow for that to occur.
So in a way, the non-designating urban frontage there, it's understandable, but at the same time, it's understandable why the city made that decision, in your opinion. But at the same time, it does kind of limit this perspective.
I think it's understandable why they did it at the time, but there's been some pretty significant changes in policies and plans since that time.
Sure, yeah. But it's not, given the fact all these things were yet to come, it does make sense why it was done that way. It's just, unfortunately for the applicant, you've got to pick up those pieces with no urban frontage designation.
Yeah, and I'll also note, just again, y'all have been dealing with a lot of requests driven by text changes. And as y'all know, we've seen a lot of text changes since the code was initially adopted and applied to commercial. So at the time, also, I'll note that the exemption from tree conservation used to be allowed not just when you had a zoning frontage, but it also was allowed when your building type required a build to, and the mixed use building type used to require a build to requirement. And so that mixed use building type build to would have trumped tree conservation in this case as well, even without a frontage. But there have been changes to remove the building type being able to trump TCA and relying on frontage. But I'll just note that that's another, change that the building type would have allowed for some of this.
All right, so my last question is, and we don't have a rendering on it because it's kind of a weird question. So if I'm going north on McDowell, and I look up to right, like what am I looking at? I'm looking at that kind of, it's not tree shade, but it's landscape buffer. What is that?
So right now along McDowell, and I don't know if we can go to an aerial slide or two away, but right now you've got a significant amount of trees that are within the right of way.
Right. That's what I was getting at. Yeah.
That will, likely as a part of NCDOT's project and putting into private hands, result in the removal of those trees. They're doing it to facilitate development in that area. And same along the south side of the property adjacent to MLK. So the plan is for that area to be, redeveloped in a more urban way.
Okay, that clarifies some stuff for me. Anybody else?
John, can I speak? Yeah, Michael, if you would go to the slide that shows where Kinley's going to come across there at Western Boulevard and ties in, you said, to a private developer, and just walk us through that just for a little bit, as John mentioned earlier about Kinley Street. And also, will that access from Western Boulevard tying into, is it Dawson Street? Will that go away?
Yeah, so what you see right here, you see Kinley Street coming through the site. You see it kind of terminates at the southern boundary of the site. Now, there's intervening right-of-way between that property line and call it the actual street of MLK.
Show us the slide. Show us the slide that shows the yellow line that you showed earlier. If staff can show that one, unless you can show it. The other one is another one.
Let's see. It might be good to have one of the BRT slides, maybe.
Yeah, I know which one you're talking about. With salt too.
Yeah. So can you see here? There's
here we go.
There's that pink line. That's essentially Kinley Street that then is going to tee into Western Boulevard.
Right.
And that will be across from, this McDowell Street ramp that's going to come here.
Yeah, if you go to the next slide, actually, that's the better one.
Yeah.
That's it.
Okay.
Yeah. So this area right here in the right of way, that's kind of in this purple where the ramp is.
Yep.
That goes away, in all likelihood gets acquired by the adjoining property owner, the applicant in this case. And as a part of that, they have the obligation to construct the rest of Kinley Street to make that connection. So there will be a full connection of Kinley between Salisbury and Western.
Okay.
That's all I know. Does that Western Boulevard access to McDowell go away when that happens?
No, that's still there.
Okay.
Right. The ramp is going away. Yes.
Yeah, the ramp will go away.
So okay.
The off ramp goes away, and then you now have an on off in that area to the left of the yellow circle.
Got it.
Okay.
Yeah, got it. Okay, I see what you're saying. Yeah.
Okay. All right. Thank you, Chairman Koontz. Michael, thank you.
Thank you.
For Michael, Kathy, everybody okay?
Yeah. Hey, Michael. Steve Kenny, I've got a question, and I know there's a lot of moving parts there. I may not have understood it all, but I'm just wondering a little bit why you're in front of the Board of Adjustment and why you're not in front of council for a full-blown rezone. So I think what you're asking us is to change this frontage requirement and effectively upzone the property and to give you some more acres to work with. And maybe I'm unclear on how you move through the city on some things, but why are you in front of us instead of council for a rezone?
Yep. So a couple items I would say. One, I'll acknowledge that yes, rezoning is, rezoning to a urban frontage is one option. It was not an option here because of some timing pressures related to some settlement agreements and obligations under those agreements to convey, to record lots and convey property by the end of the year. So when this issue was raised, to be frank, it was going to be, is there a legislative solution at the legislature? Because a rezoning is not going to get done within 3 months. A rezoning is a minimum 6-month, 7-month process. And so the variance process was identified as, an appropriate route that would allow for the timing. It's a 2 to 3 month process to allow for the timing. And, at the same time, we felt like there were also some valid and legitimate, hardships on the property that would qualify for a variance as well. I don't want to say that rezoning is not theoretically an option, but there were reasons why that was not pursued. And I want to just maybe respond to one part of your comment, which was kind of, from an upzoning standpoint. Again, through the frontage application, or the application or addition of a frontage, certainly we would not be gaining any additional height. But yes, we would be allowed to develop in an area that would otherwise be restricted by, these trees. But again, these trees in a very short time would no longer be in an area that would qualify for tree conservation once DOT abandons that right of way. And so all of a sudden we would be stuck with designated trees that no longer qualify. But they would be on a plat, and really there's not a great process to change that. So.
Any other questions on that before we dive into, I think your next step is going to be to kind of dive a little bit into the contingency offering?
Yes, sir.
All right, let's do that.
Okay, great. Right, so you have the condition here. So this condition was based on UDO section 9.1.8, which is used when tree conservation has been established, but then someone goes in and removes those trees. There's a requirement, under 9.1.8 to either restore with new trees or pay a replacement fee. The requirement to plant new trees, there's a minimum, caliper inch, and so that's how trees are measured. Kind of, it's somewhat the diameter at breast height, but that's
I get that. I want to make sure everybody else understood it.
Yeah.
It's basically how you measure a diameter of a tree.
Yeah. So we incorporated that standard into the condition. Also, we used the 9.1.8 method for generating the replacement fee and which is $100 per caliper inch of trees removed. So we looked at the 12 trees that result in, 265.1 caliper inches. So that result, we either have to replant trees that equal that caliper inch total, or the code allows the payment of a fee equal to $100 per caliper inch of removed trees. So that's how we arrived at the 26,510. So, and then the way we set up the condition is the payment of the fee, which could then be reduced through the planting of trees, that meet that minimum 2 caliper inch standard.
It's basically an escrow in a way.
Yes, I mean, it can be looked at like that. Yeah, I mean,
Functions as one, yeah.
Yeah. I mean, we will be, as part of the development of the apartment lot. And so I'll kind of touch on the balance of the condition, where we've said that we can plant. So we've essentially gotten authorization from the North Carolina Railroad to plant a portion of their corridor because we're having to grade in there to install the 10-foot multi-use path. And so we anticipate, heavy landscaping along that area. We also anticipate, landscaping along Kinley and in the future, on those other developable sites, lots 2 and 3. The reason that we did not want to trigger compliance on lots 1 and 4 is because lot 4, we know we have to plat and convey by the end of the year. And lot 1 has already received, preliminary site plan approval. And so it's essentially, the next, prior to the next development, which will be on lot 2 or 3, that's when we would have to satisfy all of this.
Yeah, and the payment to the city would be made after you get that C of O. So you probably ought to make some statement about within X days of getting the C of O. There's no real exact timing on when the payment's made.
Yeah, that's great. We're happy to do that. Yeah, so I was thinking, from a tree planting standpoint, that would certainly happen prior to the C of O, because that's kind of part of the inspections call it is that those trees have been planted. But we can certainly say, add that money will be delivered to the city within 3 days to if not before the CO is granted. I mean, we're happy to do it prior to the CO.
I said, no later than 5 days or something like that.
The way it reads now, if I was reading it, is that you either have to pay or plant by the time you get your issuance of the CO.
Yeah, and we're fine keeping it that way, that it's prior to the CO. I mean, that's the city's hook,
Oh, I see. Okay, yeah. All right, so can we talk real quick about that 26,510? That's derived from a formula in the UDO section 917 or whatever. Is that how that was reached?
That's right, 9.1.8. Yep, that's the replacement fee calculation.
Okay, and that's okay. Got it. Okay. Any questions on this contingency? Condition language, I should say. Condition language from Michael from the board. Do you still have more to lay out for us, Michael, outside of this?
No, sir. I think I've touched on everything, but happy to answer any questions.
And you've got two, Buckman and Richards are here to speak, or they need to, or is that only if you need it, or?
No, it's just in case there were questions.
Okay. All right, no additional participants to support or no opponents on this, which is notable. Anything further? Michael, you good?
I'm good. Yeah, you're right to note that there's nobody in opposition from a property owner standpoint and also from a city standpoint.
Eric, anything further from you, or was that Justin who did this?
This was me. No, there's nothing further from me.
Okay. All right. Any board questions?
Well, just for Steve's question for Michael. So Steve, did your question get answered from Michael earlier about why is it before us versus city council?
Yeah, I understand exactly where Michael's coming from,
Okay.
and I think you did a good job presenting the case. I think, to be very candid, I think his applicants put him in a tough spot. I'm not sure I agree that this should be in front of us. I'm not, maybe Catherine can help.
Yeah, I was gonna say.
I'm not aware of Board of Adjustment approving a fee in lieu for trees. Maybe we have, but is that something we've done before?
We don't have any issue with the condition language. I think the intent is that to, as the applicant said, or applicant's attorney, to meet the intent of the ordinance requirement for planting the trees, since they can't do it in the location that the UDO might call for. They're saying they'll either plant or pay. So we have no, I have no issue with the board accepting this condition if you would like to.
Okay.
Okay, thanks.
Yeah, and Mr. Chair, this is Michael Birch. I just wanted to note, this board really since 2016 has seen a significant number of variances to, frontage standards, essentially, all of which, or at least most of which, could have been resolved through the rezoning of the property. And so I just want to, it's not exactly on point, as to this issue, but there's been a significant number of requests driven by a frontage that was applied. And instead of going through the rezoning process just to remove that frontage, the applicant instead elected to come to the Board of Adjustment. So I did want to make that note.
Yeah, and Michael, thanks for saying that. That's kind of what I needed to hear. I just didn't, I wanted to be sure we weren't used as kind of a bailout, maybe something that went wrong. So thanks for saying that.
Yes, sir. Thanks.
Any other questions for the applicant? If not, we can move to board deliberations and close the evidentiary hearing. All right, let's deliberate. I think your questions are great one, Steve, regarding, I mean, it does feel like kind of a last resort thing, because I think it kind of is. I think it's, they're in a bind. I understand timing of that, and I also understand that, as a board and as an agency for the city, we want to be respectful of that. And you can call it creative, but at the same time, I think it does, bring to light the largest obstacle they have, to doing business as well. So I'm inclined to approve with conditions, or I'm certainly going to make the motion for that, unless I hear anybody else deliberate something that I perhaps haven't thought about. So let's talk it up, or if you want to second it, I understand that too. Thank you.
I'm good with it as well.
Okay. Well, on that note, I'll make into a motion to approve with conditions, and the conditions will be, unless Catherine has something in that condition, which I believe I heard she say that she was okay with the way that was written. There was nothing else we need to think about.
I'm fine. If the applicant wants to offer this as a condition, I have no issue with it. And I think the way it reads, it sounds fine to me. So.
Well, I think it's proposed as it is, with the condition that was presented. So I'll make a motion to approve with the condition we studied. Is there a second?
Second.
All right. I'll reach back out to Michael. Is there anything, are you good with the conditions, Michael, proposed
Yes,
as they are?
Yes, sir. I'm good with the conditions, and I believe it addresses Ms. Rudisill's comment earlier that payment is required prior to the issuance of the CO. So.
Okay. All right. All right. So I have a motion by me. Marvin is the second. Ralph.
Thank you. And if we could please make sure I get the wording of that condition sent to me, because it's not in the presentation that was attached to board docs.
Okay.
Okay, on the motion to approve with the condition, Vice Chairman Kuntz.
Approve.
Thank you, Mr. Sutton.
Approve.
Thank you, Ms. Rudisill.
Approve.
Thank you, Mr. Kenny.
Approve.
Thank you, Mr. Buckler.
Approve.
Thank you. That makes 5.
All right, and I have that as the last case of the day. So we can close the review portion of the meeting and we can move to the approval of the September 13th minutes. Everybody a chance to review those if needed. Or I'll entertain a motion.
Approve.
Second.
All right, Ralph?
Okay, on the motion to approve the minutes as presented, Mr. Butler?
Approved.
Thank you, Mr. Sutton.
Approve.
Thank you, Vice Chairman Coons.
Approved.
Thank you, Mr. Kenny.
Approve.
Thank you, Ms. Rudisil.
Approved.
Thank you.
All right, anything from you, Catherine?
Nothing for me. Good job. The first remote chair duties.
Yeah, well, it was a lot of going back and forth, but I think it was a good meeting, and I think the presentation, as always, a good presentation helps us review more efficiently, and I thought they were, even the one we denied, I thought was well presented. I just think the case was stronger for denial on that one, and I think the last case was I appreciate, Catherine, you sending those conditions out early and some of the other components that were unique about that one. So, and good question, Stephen. I thought that was a good question there. If there's no other business we need to talk about, we can adjourn and then reconvene on in our November meeting. Is that it?
Sir.
Yeah, you did it.
Yep. Thank you.
Thank you.